Grade 1, grade 13, seat number 37. Grade 13,
Complaint. What is to be complained? What is to be complained? ಏನ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು ಇವ್ರೆ? ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ವಜಾ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ ನಾನು. ಎಸ್, ಪಾಸ್ ಇಟ್ ಓವರ್. 8 ವರ್ಷ ಆಗಿದೆ, ಇನ್ನ ಕೇಸ್ ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ. ವೇರ್ ಆರ್ ಯು? ವಾಟ್ ಆರ್ ಯು ಟ್ರೈಂಗ್ ಟು ಸೇ? ನಿಮ್ ಎದುರುಗಡೆನೆ ಡಿಕ್ಟೇಷನ್ ತಾನೇ ಆಗಿದೆ, ಮತ್ತೆ ಕಾಪಿ ಹಾಕ್ಬೇಕು ಅದಕ್ಕೆ. ನೀವ್ ಇರ್ಲಿಲ್ವಾ? Irli, let it be there. If you are not complied, it will be dismissed. You can take it. ಹೌದು. Alright, at request of both, release this matter on 2/11. ಇಲ್ಲ ಅದು ಕೊಡಕ್ಕಾಗಲ್ಲ. ಎಸ್, What is this matter? Why do you want time? Yaru. All right, at the request of counsel for appellant post application. ಆಯ್ತು All right, at request of counsel for appellant adjourned after vacation. ಡೋರ್ ಲಾಕ್ ಅಂತಿದ್ಯಲ್ಲ issue fresh notice through speed post to R1A. Process to be paid forthwith. Release this matter on 2/11. Narayan Swami.
Second matter, my lord, I appear.
In pursuance of the order of this court. In pursuance of the order of this court, court notice is issued to Yarge. Respond number 1.
Yes, my lord.
The same is served personally. Respondent called out. Kariri. Respondent called out. Called out absent. Posta. Release this matter on 2/11 for hearing. Huh? People book for it. Can you exhibit ಏನು? ಏನಂತದ್ದು? Memo with exhibits of P series and D series are filed. Same is accepted. Let a copy be served on the other side. Release this matter for hearing soon after vacation. Nadina Logan. In pursuance of the order dated 27/9/2023, notice to LRs of deceased R10 and 11 has been published in Hosadiganta Daily dated 4/10/2023. Legal representative of deceased R10 and R11 called out absent. In order to facilitate the legal representatives of deceased R10 and R11 to engage a counsel, release this matter on 2/11. Ramakrishna. All right, 31/10. M. Ramakrishna. ಅವತ್ತು ಆರ್ಡರ್ ಆಗಿದೆ ಅದು 6/8 ಅವತ್ತಿಂದ ಹಾಕಿಲ್ಲ. Week's time is finally granted to file the paper books. None appears for the appellant. Week's time is granted finally to file paper books. Otherwise, the matter be listed for dismissal. ಯಾವತ್ತಿಂದ ತಗೊಂಡಿಲ್ಲ ಅವರು. All right, ಬರ್ಕೊಳ್ಳಿ. none present on behalf of the appellant. Appropriate steps are not taken to serve the respondent number 6 despite granting sufficient time. Accordingly, appeal stand dismissed as against R6. Week's time is granted finally to file the paper books. Otherwise, the matter will be listed for dismissal.
7, my lord. Lord, IPA for the appellant. I
Okay.
have
In persons of the court are dated 27/9/2023, notice to respond number 5A and 5C are published in
Kannada Prabha.
daily dated Kannada Prabha daily newspaper dated
410.
4/10/2023. R5A and C called out absent. In order to facilitate the R5A and C to engage a counsel released on 2/11.
Please, ma'am.
ಅದ್ರಲ್ಲಿ ಸತ್ತಿದ್ದಾರೆ ನೀವು ತಗೊಂಡಿಲ್ಲ ಸ್ಟೆಪ್ಸ್ ನ. ನೋ ಮಿಸ್ಟರ್, ಅದರಲ್ಲಿ ಕನ್ಸರ್ನ್ R5A, R5 ಯಾರಿದ್ರು ಅದ್ರಲ್ಲಿ ಇವ್ರು ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಗ್ತಾರೆ? ತಮಗೆ ಹೇಳೋದು ಅರ್ಥ ಆಗುತ್ತೋ ಇಲ್ಲೋ? ಮೈನ್ ಅಪೀಲ್ ನಲ್ಲಿ R5 ನಿಮ್ಮ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಸುಮ್ಮನೆ ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಂದ್ರೆ ಅವ್ರು ಇಲ್ಲಿ ಸತ್ತೋಗಿರೋರ್ ಮೇಲೆ ಇರುವಾಗ ಅಲೋ ಮಾಡಕ್ಕಾಗತ್ತಾ? R5 in main appeal is which respondent in your cross objection?
He is respondent number 10, my lord, in crop.
ಅವ್ರು ತಗೊಳ್ಳಿ, ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಡವಾ ಅವ್ರಿಗೆ? ಬೇರೆಯವರೆಲ್ಲ ಅವ್ರು ಬರ್ದಲ್ನೇ ಮಿಕ್ದವ್ರು ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. GS ಪ್ರಸನ್ನ ಕುಮಾರ್. GS ಪ್ರಸನ್ನ ಕುಮಾರ್. No, where is Mr. Prasanna Kumar? ಅವರು ಕೊಡ್ಬೇಕಲ್ಲ ಮೆಮೊ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್. ತಾವು ಕೊಡಿ, ತಮ್ಮ ತಗೊಳ್ಳೋಣ, ಅವ್ರದ್ದು ಕೊಡ್ಲಿ. Yes, ma. Pass over. Memo of calculations filed by both the parties taken on record. ಎಷ್ಟಿದೆ ನಿಮ್ ಪ್ರಕಾರ ಅಡ್ಮಿಟೆಡ್ ರೆಂಟು? What is the arrears? 4 lakh? No, what is the arrears ಅಮ್ಮ ಇವಾಗ ಫರ್ದರ್ ಇದೆಯಲ್ಲ? You have taken possession only for arrears of rent. So how much amount was due according to you? 4,58,000. They have paid 2,50,000 and odd. Everybody ಅವ್ರದ್ದು ಎಷ್ಟಿದೆ ನಾವು? According to you, another 2,09,000 rupees is due. Mr. Vasan. 2,03,00,000. According to them, they are only due in a sum of rupees. How much you have to pay? Admitted ಎಷ್ಟಿದೆ ಅಷ್ಟು ಕೊಟ್ಬಿಡಿ, ಮಿಕ್ಕಿದಾದ್ಮೇಲೆ ನೋಡೋಣ. ಅಡ್ಮಿಟೆಡ್ ಪ್ರಕಾರ 2 months ಬಿಟ್ಬಿಟ್ಟು ಮಿಕ್ಕಿದ್ ಬಾಕಿ ಇದೆಯಲ್ಲ ಅದನ್ನ ಕೊಟ್ಬಿಡಿ. ನೀವೇನು ಅಡ್ಮಿಟೆಡ್ ಬೇಡ, ಯಾವತ್ ಖಾಲಿ ಮಾಡಿದ್ರಿ? If you are ready, I will dispose of the appeal on merits. Why? You have not admitted, no? You have, when did you vacate? Was it by court procedure? Hmm. We continue to be in possession. ಮತ್ತೆ ಮಾಡಿ ಅದನ್ನ ಕೊಡಿ ಎಷ್ಟಿದೆ ಅದ ಹೇಳಿ ನಿಮ್ದು you have to show discharge, you have pleaded discharge, no? You will have to show how you have paid. What was the mode of payment? By cash or check earlier. ಮತ್ತೆ other than check, what is there? Small. Yes, argue. Argue, no? ಅಲ್ಲಮ್ಮ ದುಡ್ಡು ಕೊಡ್ಬೇಕಾದ್ರೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಎಲ್ರಿಗೂ. When you need to pay the money, it's always inconvenient. You continue. You are what instructions? Trial court, your client has given a deposition before the court. Beyond that, you can't argue. Tell me how you have discharged the entire payment. Plea of discharge, no? I paid everything. That is the plea. Show from records what is it that you have paid. I'll pass it over, you argue the matter. Madam, breathing problem in Bangalore aggravates in November and December. We'll have to wait up to March for the breathing problem to set right, right? Now next 2-3 months are colder months. Up to January end till Sankranti. Anybody having the breathing issues will aggravate in Bangalore. Not only because of the cold atmosphere, but also for the reason of pollution. What do you do? When do you argue? 2nd November. All right. At request of counsel for appellant, release this matter on 2nd November for final hearing. ನೋಡಿ ಅದೆಲ್ಲ ಏನಿಲ್ಲ, ಅಲ್ಲೇ ಕಂಟಿನ್ಯೂ ಆಗ್ತಾ ಇದ್ರಿ, ಅವ್ರ ಜೊತೆ ಒಳ್ಳೆ ರಿಲೇಶನ್ಶಿಪ್ ಇಟ್ಕೋಬೇಕು. ಏನಿದೆಯೋ ಕೊಟ್ಬಿಡಿ, ಕೊಟ್ರೆ ಮುಗಿಸೋಣ. ದೇವಿ ಗಂಗಾಧರಪ್ಪ, awaiting service of notice to proposed impleading response. 13 and 14 release this matter on 3/11. Awaiting service of notice to R1 and R2 release this matter on 3/11. ಎಲ್ಲ ವಾಪಸ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅದು. What happened? Just check up. Why is she shouting? ಜಾಗ ಬಿಡಿ ಇವ್ರೆ. ಡಾಕ್ಟರ್ಗೆ ಫೋನ್ ಮಾಡಮ್ಮ. ಡಾಕ್ಟರ್ಗೆ ಫೋನ್ ಮಾಡಿ ಅವ್ರು ಸ್ವಲ್ಪ ಜಾಗ ಬಿಡಿ ಕೇಳಿ, ಎಲ್ಲ ಮುತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಫ್ರೆಶ್ ಏರೇ ಇಲ್ಲ. ಗೊತ್ತಾಯ್ತಪ್ಪ, ಸ್ವಲ್ಪ ಜಾಗ ಬಿಟ್ರೆ ಎಲ್ಲ ಫ್ರೀ ಆಗತ್ತಲ್ಲಿ, ಫ್ರೆಶ್ ಏರ್ ಬರ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ. Yes, you have to take fresh steps. At request of Sri Jagannath, release this matter on 26/10 for taking appropriate steps to serve answered respond number 1. No, all those things are not going to work. In addition to taking appropriate steps, counsel for appellant is permitted to serve the advocate who represents the first respondent in the trial court in final decree proceedings and file acknowledgement. Sanat Kumara, awaiting service of notice to the LRs of second respondent, release this matter on 31/10. Shravan Lokre, ಅಲ್ಲ ಅದು ಎಸ್ಟರ್ಡೇ ಆಲ್ ಡೇ ಆಫ್ಟರ್ ಎಸ್ಟರ್ಡೇ ಅಲ್ಲ, ಇವತ್ತು ಪಬ್ಲಿಷ್ ಆಗ್ಬಿಡ್ಬೇಕಾಗಿತ್ತು. Don't say all those things. I am to dismiss your application. ಅವ್ರಿಗೇನು ಹುಚ್ಚಿಡ್ದಿರುತ್ತೆ ಹಂಗ್ ಬರೆಯಕ್ಕೆ. ನಿಮ್ ಕೆಲ್ಸ ನೀವು ಮಾಡ್ಬೇಕು ಹೋಗಿ. 2 ಟೈಮ್ ಹೋದೆ ಬರ್ಲಿಲ್ಲ ಅಂತ ಯಾರು ಕೇಳ್ತೀರಿ? ಯಾವತ್ತು ರೆಡಿ ಆಗಿದೆ ಅಮ್ಮ ಡ್ರಾಫ್ಟ್? No, let him understand what submissions he has to make. 30th September it is ready. You have not collected the draft. When is the date that we have fixed it? Mate, why do you say that it is not ready? Draft is ready, you have not collected. How much cost? 10,000? No, let him understand now. If he makes a false statement before the court, we are not going to leave it just like that. We will impose 10,000 rupees cost. He is blaming our office. Then he should be, cost must be 20,000. In Janmepi atara matadbardu, accusing the office. ಸುಮ್ಮನೆ ಏನೋ ಬಾಯಿಗೆ ಬಂದಿದ್ದು ಸುಳ್ಳು ಹೇಳ್ತೀರಿ ಕೋರ್ಟ್ ನಲ್ಲಿ ನಿಂತ್ಕೊಂಡು. ಮತ್ತೆಂತದ್ದು ಅಲ್ಲಿ ರೆಡಿ ಮಾಡಿ ಇಟ್ಬಿಟ್ಟು ಕಾದ್ಬಿಟ್ಟು ಬಾರೋ ಅಣ್ಣಯ್ಯ ಅಂತಂದ್ರೆ ಬರಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಮನೆಗ್ ಬಂದು ತಂದ್ಕೊಡ್ತಾನೆ ಆಫೀಸ್ ನಾನು. ಸುಳ್ಳೆಲ್ಲ ಹೇಳ್ತೀರಿ ಕೋರ್ಟ್ ನಲ್ಲಿ ನಿಂತ್ಕೊಂಡು. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಗಳಿಗೆ ಎಂಬರಾಸ್ಮೆಂಟ್ ನೀವು ಮಾಡೋ ಅಲ್ಕ ಕೆಲ್ಸಕ್ಕೆ ಗೊತ್ತಾಯ್ತಲ್ಲ. ಯಾಕೆ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಿ? ಯಾವ ಫೈಲು ನನ್ನ ಚೇಂಬರ್ ನಲ್ಲಿ ಒಂದು ದಿನದ ಮೇಲೆ ಉಳ್ಕೊಳ್ಳಲ್ಲ. ಬೆಳಗ್ಗೆ ಆಗಿದ್ ಮಧ್ಯಾಹ್ನ ಆಗಿದ್ ಸಾಯಂಕಾಲ. If there is a delay, it could only be one day because of Saturday or Sunday. That's all. Why do you say that it is not ready? It is ready on 30th. They have signed it. You have not taken it and then published it in the paper. And whereby we have lost valuable time. All right. It is reported that draft publication matter is not collected for issue of notice to R2 to R6 by the appellant. Sri Suresh Lokre, learned senior counsel, submits that there is a communication gap whereby the draft could not be collected from the office. Issue notice to R2 to R6 and R8 to R11 by fixing the date of hearing as 9/11/2023 and publication to be made on or before 30th October on payment of cost of rupees 1,000 to the Karnataka High Court, State High Court Legal Services Committee. Shashikant Prasad, in persons of the notice dated, in persons of the court order dated 27/9/2023. Notice to sixth respondent is published in Vasadiganta newspaper. Which edition? Mangalore edition. Respondent number 6 called out absent. In order to facilitate the sixth respondent to engage a counsel, release this matter on 2/11. ಅದಾಗ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ. NR Nayak,
This case, my lord, one notice has been issued, one left the matter. I'll take necessary step. IA1 kindly may be dismissed, my lord. Not pressed.
IA1 of 2016 is dismissed as not pressed as submitted by Sri NR.
IA1 16, 23.
IA1 of 2023 is dismissed as not pressed. Not pressed as per the submissions made by Sri NR Nayak. Release this matter on 2/11 for taking appropriate steps.
Please, man.
In pursuance of the court order dated 27/9/2023, notice to unserved respondent. Obrena sole respondent. Notice to respond number 1 to 3 is published in newspaper South India within single quote South India Times dated 4th October 2023. R1 to R3 called out absent. In order to facilitate R1 to R3 to engage a counsel, release this matter on 2/11. Yes, Bhuvan. ಯಾವತ್ ಸತ್ತಿದ್ದು ಮತ್ತೆ ಮುಗ್ದೋಯ್ತಲ್ಲ ಬಿಡಿ, ಅವತ್ ಬೇಕಾದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ, ನೋಟಿಸ್ ಬರ್ಕೊಳ್ಳಿ, ಆಯ್ತು. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 12 said to have died on 3/10/2017. Full stop. Appropriate steps are not taken to bring the legal representatives of deceased R12 on record. As such, appeal stand dismissed as against 12th respondent as by operation of law as abated. Even beko application haki. Chandan Rao, in pursuance of the order dated 26/9/2023, notice to respondent number 1 is published in Kannada Papa newspaper Bangalore edition and Business Standard Mumbai edition dated 2/10/2023. Respond number 1 called out absent. In order to facilitate this respond number 1 to engage a counsel, release this matter on 2/11. PB Shivakumar. PB Shivakumar. None present on behalf of the appellant. Release this matter on 26/10 for taking appropriate steps. ಯಾವತ್ತಿಂದ ಕೊಟ್ಟಿಲ್ಲ ಅವರು. ಅಡ್ಮಿಟ್ ಆಗಿದ್ಯಾ? ಅವತ್ತಿಂದ ಕೊಟ್ಟಿಲ್ಲ. ಪಾಸ್ ಓವರ್. Ravisha. All right, serial number 20, none present on behalf of the appellant. Week's time is granted, do the needful. Otherwise, the appeal be listed for dismissal. MG Ravisha. ಏನದು ಡಿಲೇ ಎಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. R7 ಮತ್ ಮುಂದೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತು. ನನ್ ಪ್ರೆಸೆಂಟ್ ಆನ್ ಬಿಹಾಫ್ ದಿ ಅಪಲೆಂಟ್. ವೀಕ್ಸ್ ಟೈಮ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್, ಡೂ ದಿ ನೀಡ್ಫುಲ್. ಸರ್ ಮೊದಲು ಪ್ರೋಸೆಸ್ ಕೊಡಿ, ಇಲ್ದೇ ಅಪೀಲ್ ವಜಾ ಮಾಡ್ತೀನಿ. ಕೊಟ್ಬಿಟ್ಟು ಬನ್ನಿ, ಪೇಪರ್ ಬುಕ್ ಡಿಸ್ಪೆನ್ಸ್ ಅಂತ. ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನೂ. ಕೊಡ್ತಿರೋ ಇಲ್ವೋ, ಈಗ ಕೊಡ್ತಿರೋ ಇಲ್ವೋ ಅಂತ ಕೇಳಿದೆ. ನೋ ನೋ, ಕೊಟ್ಬಿಟ್ಟು ಬನ್ನಿ. ಇನ್ನ ಕೊಟ್ಟೇ ಇಲ್ಲ. All right, week's time is granted finally to take appropriate steps. Barley pass over. ಏನಾಯ್ತಿದೆ ಅವ್ರು ಸತ್ತೋಗಿದಾರಲ್ಲ. It is submitted that Sri K. Chandrasekhar Achar, Lagat Council representing the appellant is no more. Issue court notice to the appellant. Hiremat. ಈ ಪ್ರಬಲಿಂಗ್ ಮೂರ್ತಿಯಿಂದ ಅವರೇನೋ ಹಸಿನ ಅವ್ರ ಹೆಸರು ನೋಡಿ ಹಿರೇತ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವ್ರು ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ ಅಂತಾರೆ. Non present on behalf of the appellant. Finally, week's time is granted to do the needful. If not, matter be listed for dismissal, for appropriate orders. Yes. Week's time is granted to take appropriate steps. Now, what is the stage today? Who has filed IA 1 of 19?
Operating on the matter.
Sure for whom? So who has filed IA 1 of 19?
Seeking for expiry interest. After 6 years, the defendant will still clarity of my case.
All right. Now, who has filed a vacating injunction? No. Which is that? What happened to I number 3? No, ಎಲ್ಲೆಲ್ಲಿ ಆಫೀಸ್ ನೋಡ್ ತೋರಿಸಿಲ್ಲ. Two, three, 4 up to 9. 9 is injunction, vacating. Are you ready? Are you ready? Why not today? So you don't want, both of you don't want the matter to go on. I don't understand this fixing the date and all. Why not today? It is listed for the same purpose, not today. What is fixing the date? Why should I fix any date if you are not interested? You filed the application, nobody has bothered to come up. ಏನಾಗಿದೆ IA 2, 3 ಎಲ್ಲ? What is IA 2? Ex parte injunction violation. 39 rule 2A. Inquiry has to go on. No, inquiry has to go on.
Subsequently,
I have filed objections. IA 2. Then I'll allow IA 2. When was IA 2 filed? 4 years have elapsed. Correct, sir. What to do? It's your case, you have argued. What is the fun in saying repeatedly that I have argued? It doesn't require repetition, no? I have understood that you have argued, but no orders are passed. I am prepared to pass orders, you argue. Not ready. No, I don't understand. You said that, you have argued and court has not passed orders. Now I am ready to hear. You argue the matter, I'll pass orders. Don't blame the court. Then you say, why do you say I have argued twice? For fun, is it? Then argue now. Sir, leave it at that, sir. Why are you repeating all these things, wasting time? Are you ready to address the arguments on all these applications now? Argue. No, these are all not going to work. When was IA 4 of 19 filed? That was also in 19. I'll dismiss that. If you don't argue. ಕೊಡಮ್ಮ ಈ ಕಡೆ ಎಲ್ಲ IAS. ಸುಮ್ನೆ ಎಲ್ಲ ಒಂದಾದ್ಮೇಲೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಡೋದು ಆಮೇಲೆ ಏನು ಮಾಡೋದಿಲ್ಲ. ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಏನ್ ಮಾಡ್ಬೇಕು? ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ. Which are the IAS? You tell me. You don't even have the list. See, there are 9. No, please. There are 9 applications now as per the office note up to 9. Which are the 9 applications? Why should it be pending? Which are those applications? So IA 1 and 9 will dispose of today. So far as IA 4 is. Yes. Password. IA 4 will be referred to the Registrar Judicial for inquiry if they have not filed it. Yes, Mr. Whether everything has been done now? It's all right. All that objection is okay. Whether all those formalities are done? Then we'll dismiss the application, no? ಏನೇನ್ ಮೆನ್ಷನ್ ಮಾಡಿದಾರೆ ಮತ್ತೆ? I'll dismiss IA 1. ಅಷ್ಟೇ, ಏನಿದೆ ನೀವು ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಂಡು ಸಪರೇಟ್ ಆಗಿ ಸೂಟ್ ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ. ನಾನೇನ್ ಮಾಡಕ್ ಬರುತ್ತೀಗ? ಎಷ್ಟು ಮಿಸ್ಟರ್ ಆಯ್ತು ಇವ್ರೆ, ಅದೆಷ್ಟು ಸತಿ ಹೇಳ್ತೀರ ಅದನ್ನೇನೆ. What is the extent that you have allotted to them in that survey number? What is the extent? No, don't say that. Don't say that. What? ಎರಡಡಿಗೆಲ್ಲ ಗಲಾಟೆನ ನಿಮ್ದು? ಎರಡಡಿ ಹೇಳ್ತು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
What they are claiming is item number 4. In Schedule C, survey number is listed. 1 of the nice room, what they claiming.
ಅವ್ರಿಗೆ ಯಾವ್ದು ಅಲಾಟ್ ಮಾಡಿದಿರಿ? ಹೋಗಿ ಜಾಗ ತೋರ್ಸ್ಬಿಟ್ಟು ಬನ್ನಿ ಅವ್ರಿಗೆ. ಅಲ್ಲ ನೀವು ಹೋಗ್ಬಿಟ್ಟು, ಅಲ್ಲ ನೀವು ಹೋಗಿ ತೋರಿಸಿ ಯಾವ ಜಾಗ ಅಂತ. You have filed objections now. Yes, argue the matter on IA 1 and 2. Why should we waste further time on that? Yes, Mr. Nagraj, you argue the matter. If you are not satisfied with what has been there, we can't help it. You are a party to it, you have signed it with open eyes. ಬೇಕಾದ್ರೆ ನಿಮ್ಗೆ ಆ ನಂಬರ್ ಒಂದು ಬದಲಾವಣೆ ಮಾಡ್ಕೊಡ್ತೀನಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಅಷ್ಟೇ. If you want ಅಷ್ಟೇ. ನಾನೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ, ನಾನಿರ್ಲಿಲ್ವಲ್ಲ ಅವತ್ತು, ತಾವ್ ತಾನೇ ಇದ್ದವ್ರು ಸೈನ್ ಹಾಕಿದ್ದು. ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ಗೆ ತಾವ್ ತಾನೇ ಸೈನ್ ಹಾಕಿದಿರಿ, ತಮ್ಮ ಕಕ್ಷಿಗಾರರು ತಾನೇ ಸೈನ್ ಹಾಕಿದ್ದಾರೆ. ಅವತ್ತು ವೆರಿಫೈ ಮಾಡ್ಕೋಬೇಕಲ್ವಾ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಏನ್ ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ, ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದ್ರ ಬೌಂಡ್ರೀಸ್ ಏನು ಎಲ್ಲ ನೀವು ನೋಡ್ಕೋಬೇಕಾಗಿತ್ತು. ನಮ್ ಜಾಗ ಯಾವ್ದು, ನಮಗ್ ಬರ್ತಾ ಇರ್ತಕ್ಕಂಥದ್ದು ಯಾವ್ದು ಎಲ್ಲ ನೋಡ್ಕೋಬೇಕಾಗಿತ್ತು. Having signed with open eyes, accepting the compromise by a judge who retired about 5-6 years earlier, you want that matter to be recalled? How can it be? How can it be? No. If no, sorry, sir. Sorry, Barkoli. Pardon, IA 1 of 2021 and 2 of 2021. No, I will not. I'll not recall the order. If you want to seek for correction. ಅದೇ ಅಷ್ಟೇ ಆಗಿರೋದು. ಬರೇ ನಂಬರ್ 1 ಚೇಂಜ್ ಮಾಡ್ತೀವಿ, ಸರ ನಂಬರ್ 1 ಎಕ್ಸ್ಟೆಂಟ್ ಎಲ್ಲ ನೀವು ಕೇಳಿದ್ರೆ ನಾನು ಅದೆಲ್ಲ ರಿಓಪನಿಂಗ್ ಎಲ್ಲ ಮಾಡಕ್ ಆಗಲ್ಲ. After 11 years, you can't think of filing a application for correction. What do you do? Please tell me. ಈಗಲೇ ಮಾಡ್ತೀನಿ ಅದು ಸರ್ವೆ ನಂಬರ್ ಆದ್ರೆ. No, sorry. All that I will not allow. All that cannot be done. ಏನೋ ಒಂದಿದೆ ಹೋಗ್ಲಿ ಪಾಪ, ನಂಬರ್ ಏನೋ ಬದಲಾವಣೆ ಆಗಿದೆ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಬಿಡ್ಬೋದಷ್ಟೇ. Now you want to go back onto the compromise is not permissible. Barkoli, pardon, IA 1 of 2021 and 2 of 2021. No, sir, I will not allow that. You please understand, you can only go for the survey number correction, not the boundaries. Survey number ಇವಾಗ ಏನ್ ಮಾಡ್ತೀವಿ, ನೀವು ಕೊಡಿ ಅಪ್ಲಿಕೇಶನ್, ಈಗಲೇ ಮಾಡಿಸ್ತೀನಿ. If you want the survey number to be corrected, right now it will be done. Yes, pass over. Correction of survey number ಗಾದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ, ಈಗಲೇ ಮಾಡಿ. ಶೇಷ್ಗಿರ್ ರಾವ್. All right, pass over. Sabahit. Notice ಹೋಗ್ಬೇಕಾ? ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟು? None present on behalf of the appellant. Perused the application IA 12 of 2023 to 14 of IA 11 of 2023 to 13 of 2023. The same are filed to bring the legal representation to deceased fifth respondent on record by condoning the delay of 4450 days and setting aside abatement. First, proposed LRs of respondent number 5 are served with the notice remained ex parte, remained unrepresented. First, suit is one for partition and right to be sued, 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 survives in the proposed LRs of deceased fifth respondent. First, accordingly, IA 11 of 2023, 12 of 2023 and 13 of 2023 are allowed on payment of cost of rupees 5,000 to the Karnataka State High Court Legal Services Committee. First, counsel to amend the cast title and file amended appeal memo. List this matter awaiting the service of notice of proposed LRs of R4 and R9 on 3/11. Nanja ready? Case called out Execute. What is this R15? Who represents R15? No, whoever they have made, if you are, if anybody is left over, you furnish the details. ತಮಗೆ ಗೊತ್ತಿದೆ ಇನ್ಯಾರಿದ್ದಾರೆ ಅಂತ ನನಗೆ ಗೊತ್ತಿರೋರು ಇಷ್ಟೇ ಜನ ನಾನು ಅವ್ರನ್ನ ಮಾಡಿದ್ದೀನಿ ನಿಮಗೆ ಗೊತ್ತಿದ್ರೆ ಇನ್ನಷ್ಟು ಜನ ಹೆಸರು ಕೊಡಿ you are a party to the proceedings you know and if you don't object I will say that these are the only people ನನಗೆ ಹೇಳೋದೇ ನಿಮ್ ನೀವು ಪಾರ್ಟಿ ಅಲ್ವೇನ್ರಿ ಇನ್ನೊಬ್ರು ಬರ್ದಲ್ನೇ ಪೂರ್ತಿ ತೀರ್ಮಾನ ಮಾಡಕ್ಕಾಗತ್ತಾ ಆಗಲ್ಲ if you have got any more list of any more errors give him the details R15 Barkuma R15 served with the notice and remained unrepresented accordingly IA1 of 2023 is allowed council to amend the cast title innu ena idarante nodi ready avare council to amend the cast title and file amended appeal memo post the matter for hearing idre inondu application haki Nagbhushna who has filed all right 10% on behalf of the appellant post after vacation Vedamurthy ಯಾಕೆ ಮಾಡ್ತಾರೆ ಈಗ ಏನಕ್ಕಿದೆ ಕೇಸು how have you explained 833 days delay but to tell me that then other things ಸಮನೆಲ್ಲ ಆಮೇಲೆ ಸಮನೆಲ್ಲ ಆಮೇಲೆ ಇವ್ರೆ who is the appellant ಯಾರಿಂದ ಸಮನ್ ಮಾಡಬೇಕು ಒಳ್ಳೆ ಚೆನ್ನಾಗಾಯ್ತಲ್ಲ ವಾಟ್ಸ್ಆಪ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಕ್ವೆಸ್ಟ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದನ್ನ ತಗೊಳ್ಳಿ ಅದನ್ನ ಹಾಕ್ಬಿಟ್ಟು ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡ್ತಿಲ್ಲ ಅಂತೇಳಿ ಮೆಮೊ ಹಾಕಿ ನಾನು ವಜಾ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ ಹಂಗ್ ಮಾಡೋದೆಲ್ಲ ಅಲ್ಲ ಮಾಡೋದೇ ಹಂಗೆ ಒಳ್ಳೆ ಚೆನ್ನಾಗಾಯ್ತಲ್ಲ ನಿಮ್ ಕ್ಲೈಂಟೇ ನಿಮಗ್ ಕೋಆಪರೇಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಯಾಕೆ ಸಮನ್ಸ್ ಕೊಡ್ಲಿ argue how have you explained the delay what sort of submission is this ನಮ್ ಕ್ಲೈಂಟ್ ಸರಿ ನಮ್ಗೆ ಕೋಆಪರೇಟ್ ಮಾಡ್ತಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ನೀವು ಸಮನ್ ಮಾಡಿ ಅಂದ್ರೆ ನಾಳೆ ಬೆಳಗ್ಗೆ ನಿಮ್ಮನ್ನ ಪ್ಯಾನೆಲ್ ನಿಂದ ತೆಗೆದಾಕ್ಬಿಡ್ತಾರೆ ಅಷ್ಟೇ
separate details of carrying a all the records created and connected all the space and after list of the record relevant file containing the grant one system published to record information. I had to collect information from the planning and about development of income place in the land in person. I recently go to charge of the office of the ALO and to place the relevant man the process. There is some delay in filing of it, delay in filing of the development and not.
ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ? ಅಲ್ಲ ಇವ್ರೆ ಡಿಲೇಗೆ ಯಾಕೆ ಕಂಡೌನ್ ಮಾಡ್ಬೇಕು ಅದ್ ಹೇಳಿ ತಾವು. ಏನಂತ ಹೇಳಿದಿರಿ ತಾವು? ಕಮ್ಯುನಿಕೇಟೆಡ್ ರೀಸೆಂಟ್ಲಿ ಅಂತ ಇಲ್ಲ. ಆರ್ಡರ್ ಆಗಿದ್ದು ಯಾವತ್ತು? ಆರ್ಡರ್ ಆಗಿದ್ದು 10/2/2012. ತಾವು ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ್ದು ಯಾವತ್ತು? 24/6/2015. ಸೊ 4 ತಿಂಗಳು ಏನ್ ಮಾಡ್ತಿದ್ರು? ಏನ್ ಮಾಡ್ತಿದ್ರು? ಏನ್ ಮಾಡ್ತಿದ್ರು ಇವ್ರೆ? ವೇದಮೂರ್ತಿ ನಿಮ್ ಸೀನಿಯರ್ ಕರೆಕ್ಟು. ಈ 24/6 ತನಕ ಏನ್ ಮಾಡ್ತಿದ್ರು BDN ಅವ್ರು ಅಂತ? ನೆನ್ನೆಯಿಂದ ಇವತ್ತಿಗೆ ಹಾಕ್ಸ್ಕೊಂಡಿದ್ದೀರಿ. ಅವ್ರು ಬರ್ತಾರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ ವೇದಮೂರ್ತಿಗಳು ಅಂತ. ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ. ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಇಟ್ಟಿರ್ತೀನಿ, ಬರ್ದೇ ಹೋದ್ರೆ ವಜಾ ಮಾಡ್ತೀನಿ. Counsel for appellant absent. Proxy press time. Proxy na junior. Proxy press time. Prayer rejected. Appeal dismissed for non-prosecution. Yes, Mister. ಯಾವತ್ ಸತ್ತಿದ್ದಾರೆ? ಯಾವತ್ ಸತ್ತಿದಾರಮ್ಮ? ಅಲ್ಲಮ್ಮ, ಆರ್ಡರ್ ಆಗಿ ತುಂಬಾ ದಿವಸ ಆಗಿದೆ ನೋಡಿ. Appropriate steps are not taken in respect of deceased fifth respondent. ಸ್ವಲ್ಪ ತಡೆದ್ರೆ ಆಯ್ತು, ಅದನ್ನ ಒಂದು ಬರೆಯೋಣ ಆಯ್ತಾ? Despite the court order dated 3/1/2020, 13/9/2021, 10/8/2023, posta. Accordingly, appeal against fifth respondent dismissed. ಯಾವತ್ತಾರು ಇರ್ಲಮ್ಮ, ನಾವು ಇಲ್ಲಿ ಹೇಳಿರೋದು ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ 3 ವರ್ಷ ಇಲ್ಲೇ ಆಗೋಗಿದೆಯಲ್ಲ. ಏನಾಯ್ತಮ್ಮ? As abated. ಆಯ್ತಾ? IA 2 of 2023, 3 of 2023, 4 of 2023 are filed to bring the legal representative deceased 8th respondent on record. Proposed LRs of 8th respondent are served and unrepresented. There is a delay of 372 days in filing the application to bring the legal representative deceased 8th respondent on record. After taking note of the fact that suit is one for partition and rights of the parties with regard to the immobile properties are to be adjudicated in the appeal, applications are allowed on payment of cost of ₹3,000 to the Karnataka State High Court Legal Services Committee. Release this matter for it is submitted that 6th respondent is no more. Release this matter for taking appropriate steps in respect of deceased 6th respondent on 2/11. Shankar Reddy.
Not AT for the appellant in this matter.
Hmm.
2C and 2D, notices have been returned. I'll ascertain the fresh address and.
Each time is granted to take appropriate steps in respect of respond number 2C and 2D. Yes. Yes, please. What is the value according to you, plaintiff?
Of the increase concerned. So I got 27 is about the lakhs. Not repeating the fact that one. But and scooters the file before the government law. It's a bare nuisance. And I have paid the value is as per 1626C.
All that is understandable. Is in similar matters, evaluation was required to be filed. Did you file?
Because I have not paid evaluations. I paid why I filed the valuations.
He so and so submits that he would undertake to appear for respond number 1 and 2. His submission is placed on record. Office is directed to reflect the name of so and so and release this matter on 3rd of November. In the meantime, the plaintiff is directed to file the specified value before the trial court in order to ascertain the jurisdiction of civil court in entertaining the suit. You can get it preponed and then file a specified value. Yes, call. No, two cases, the specified value has been made as 2,90,000. And I have disposed of those 2 cases, 2 or 3 cases. 2 or 3 cases we have disposed of last Friday. And only 1 case is now pending. Now let it be there. Let it be there, we'll consider it. Hmm.
What's taking a different from that, taking what the apartment is the first floor. This specific apartment ground floor. The price was there, no, the objector has very some other.
Which order you are challenging?
All of us.
What is dismissed?
That is our.
That order that you have enclosed is 27 September 2014. That application is dismissed. Admit. Call for trial court. Hmm. Hmm. What is your right? Hmm. Hmm.
Hmm.
Yeah.
Hmm.
Yeah.
Hmm. 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 Hmm.
Yeah.
Hmm.
You should have got it referred to the expert if you are so, sure that the signatures are not yours. No, no, it will go to the date of sale. When did you file the suit? 94. Hmm. Was it a registered document, GPA? Not a registered document. When did you come to know that such a fraud has been played?
Yeah.
All right, what about the question of signature? You tell me that. Hmm. All right, admit. Where is the time, Mr. Manian? You know the court is working for 2005 matters. No, it's not being heard. What to do? That is the order of the day. And you saw the other gentleman saying that he is not ready after 8 years. For admission, he is not ready. What to do? And he says the BDA commissioner is to be summoned. And BDA is the appellant. Madana, estaguttೋ ಅಷ್ಟು ಮಾಡೋಣ. See, people are standing in the queue from 2005, 6, whatnot. So in such circumstances, what is possible within the scope and the time that is available in the roster? Iga, since the list is now there published in the website, from 25th October, 3 days, and 2 days in the October, 5 days in October, and about 5 plus 7, 12 days, and another 3-4 days in second week, and 5 days in the last week, and 2 days in the last week of November. So put together about a month, and thereafterwards 10 days. So that is the time at my command in this roster, say roughly 40 days. Now 40 days, how many matters we can think of? That should be the target. Right? So if I have that systematically worked out, I think good number of cases gets disposed of. This roster also, that is coming to end tomorrow, I've been able to dispose of about 120 plus on merits, the first appeal. Great achievement, you see. Yes. CG Malayil. ಇವತ್ತು ಸತಿನ ಬಂದಿಲ್ಲ ಅಲ್ಲ. 2-3 ಸತಿ ಬಂದಿಲ್ಲ. ಅದೇ ಬೆಳಗ್ಗೆ ಟೈಮ್ ಕೇಳೋದು ದುಡ್ಡು ಕೊಡ್ತೀನಿ ಅಂತ ಪಾಸು. ರಾಜಗೋಪಾಲ್. What is this, Mr. Abhinav?
My lord, this is a suit for partition. My lord, except those properties, my lord, which have been sold. My lord, partition is granted. Therefore, my lord, insofar as the purchasers are concerned, there is a common tactic, my lord, first to sell and then to say, my lord, it is a joint family property. No case is made out for admission, my lord.
Yes, what is your problem with the allotment of shares? Which item? That was not available for partition is the finding of the trial court. No, when it was sold. No, when it was sold, the last day, last sale, when it was made. 2015. When was the first sale? 98. 96. When did you file the suit? Then how is it possible that property must be available for partition, no? What were you doing from 96 to 2008? No, sir. Tell me how it is maintainable so far as the first item is concerned. First item ಬರೋಣ ಮೊದಲು ಆಮೇಲೆ 2 ಹೋಗೋಣ. ಎರಡು ಒಂದೇ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ. When was it sold? Who was, according to you, who is the owner of the property? Agreed. So who told this? Who sold this property? How can you alone sell it after death of father, Mr. Abhinav? You have alone sold, I am told. ಅದೇ ಅವ್ರದೇನೋ ಬರ್ತಾ ಇಲ್ಲ. Not being here. No, I am not able to hear you.
Sir, re-login ಆಗಿ sir.
ಇಲ್ಲಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದೆಯಾ ಕೊಡಿ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಮ್ಮ ಇದರಲ್ಲಿ ಕ್ಲೈಂಟ್ ಇದ್ರೆ ಕೊಡಿ 90 90 all right you read the cause of action para ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಅಲ್ಲಿ ತನಕ ಅಂತ what are you doing till then what are you doing till then
Am I audible, my lord?
yes and how can you sell it on your own when the father property was the father's property
My lord, there was an earlier partition. May I just request for a passover, my lord? I'll just come there and give the sequence of events, my lord. It's not clear, my lord. My apologies.
all right pass over yes Gauri Shankar yes madam ನಮ್ಮ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಓದ್ಬಿಟ್ರೆ ಸಾಕು ನಾನೇನು ಹೇಳೋದ್ ಬೇಡ ವಾಟ್ ಇಸ್ ದಿಸ್ ಕಾಮತ್
I feel that to complete this and opportunity.
who says that complete justice should not be done you must look at it this fellow also no
There are some documents which what you have been producing before has not been used. Now you are saying your lordship's
you know very well that appeal is not a supplementary examination how can I allow you to write the answers now after going back home taking the question paper consulting the book and then plugging the loopholes
look at those documents.
it's only a revaluation that's all
Those are material documents.
you know 96 scope I can re-evaluate what has been there in the papers not allow the party to turn around and then say I got this I got that why did you not file it an opportunity was there suit is not an ex parte suit judgment is not an ex parte judgment it was contested tooth and nail cross examination has been done your own directors are responsible already the fellow has been penalized for that Bindur's matter he has been penalized ನಿಮ್ಗೇನಾದ್ರು ವಕೀಲರ ನೇಮಕ ಮಾಡ್ಕೋತೀರಾ ಶ್ರೀ ಕಾಮತ್ Arvind Kamath is it Arvind Kamath learned senior counsel represents the appellant seek short accommodation to place additional evidence on record respondent earlier engaged the services of Sri Anant Mandigi and after he has been designated as senior counsel, comma, he needs to engage a separate counsel, first. Appeal is of the year 2007. In order to facilitate the respondent to engage a separate counsel and appellant to place the additional material on record for consideration of the appeal on merits, release this matter on 31/10. Yes, madam. ಕೇಳಮ್ಮ. ಹಾ? ತಾವೇನಾದ್ರು ಹೇಳಿದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ ಅದನ್ನ ತಗೋತೀನಮ್ಮ ಅಷ್ಟೇನೆ. ಸುಮ್ನೆ ಅರ್ಧಂಬರ್ಧ ಐತಿರೆಲ್ಲ ಸುಮ್ನೆ ಕೆಲವು ಸೆಂಟೆನ್ಸಸ್ ಹೇಳೋದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಅನ್ಸ್ಕೊಳಲ್ಲ. ಜಗದಮ್ಮ ಅವರು ಒಂದು ಕೇಸ್ ಹಾಕಿದ್ರು, ಆ ಕೇಸ್ ವಜಾ ಆಗಿದೆ, ಮುಂದೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ. ವಾಟ್ಸ್ ಹ್ಯಾಪನಿಂಗ್ ಇನ್ ದಿ ಕೋರ್ಟ್? ಬೆಳಗ್ಗೆಯಿಂದ ಬರೀ ಲಾಯರ್ಗಳದೇ ಮೊಬೈಲು. ಅದೇ ಗೊತ್ತು, ಅದೇ ಆ ಗಲಾಟೆ. ಅದೆಲ್ರಿಗೂ ಬರ್ತಾ ಇದೆ. ಅದು ಪುಣ್ಯಕ್ಕೆ ನನಗಿನ್ನೂ ಬಂದಿಲ್ಲ. ಇಟ್ರು ಬರುತ್ತೆ. ದಿ ಓನ್ಲಿ ವೇ ಇಸ್ ಟು ಪುಟ್ ಆಫ್ ಸಮ್ ಎಮರ್ಜೆನ್ಸಿ. ಮಾಕ್ ಎಮರ್ಜೆನ್ಸಿ. It may ring. ವಜಾ ಆಗಿದೆಯಲ್ಲಮ್ಮ, ಮುಂದೆ ಏನ್ ಹೇಳಿ ತಾವು ಹೇಗೆ ಅದಕ್ಕೆ how you can say that this particular case could be further proceeded? ಅಂತದಂತೆ ಏನ್ ಡಬಲ್ ಸೆಲ್ಲಿಂಗ್ ಅಮ್ಮ? ನೀವ್ ಯಾರು? ನೀವು ಓನರ್ ಹೆಂಗೆ? ನರಸಿಂಗನ ನಾರಾಯಣನು? Unless you seek title, how can I do that? No, they are given the certificate. No, BD has given the certificate to the Narayana. No, madam, please understand. ನಾರಾಯಣ ಅವರು ಕೊಟ್ಟಂತ ದಾಖಲಾತಿಗಳನ್ನ ಗಮನಕ್ಕೆ ತೆಗೆದುಕೊಂಡು ಬಿಡಿಎನ್ ಅವರು ನೀವು ಪೊಸಿಷನಲ್ ಇದ್ದೀರಿ ಅಂತ ಅವ್ರಿಗೆ ಪೊಸಿಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. If you want to say that Narayana is not the person who is the owner, file a suit for declaration. ನಾನು ತಮ್ಗೆ ಹೇಳ್ತಾ ಇರ್ತಕ್ಕಂಥದ್ದು. ಆಯ್ತಾ ಇನ್ನೇನಾದ್ರು ಇದೆಯಾ ಹೇಳೋದು? ಥರ್ಡ್ ಶ್ರೀಮತಿ ಮಿಸಸ್ ಸಂಗೀತಾ. What do you say?
The application is one different type of command. The application is happening.
ಆಯ್ತು, ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿ. ಅನನ್ಯ ರೈ ಫಾರ್ BDA ರಿಸಾರ್ಟ್. ಎಸ್ ನಂದೀಶ್ ಪಾಟೀಲ್. ಏನ್ ಕೃಷ್ಣಮೂರ್ತಿಗಳೇ? Let us not allow it to come next time before me. ಬರ್ಲಿಲ್ಲ ಅವರು. ಅದ್ಯಾಕೆ ಸುಮ್ನೆ? ಬರುತ್ತೆ ಈಗ ಎಲ್ಲ ಲಿಸ್ಟ್ ಬಂದ್ಬಿಟ್ಟಿದೆಯಲ್ಲ. ಇಲ್ದೇರು 2006 will get the priority. 2006 will get the priority in the economy. ಅವ್ರು ಯಾರು ಇದ್ದಾರೆ ನೋಡಿ, ಸಾಜಿ ಜಾನ್ ಇದ್ದಾರೆ. Who has took now? ಸತ್ಯನಾರಾಯಣ ಗೋಪಾಲ್ ರಾವ್ ಅವ್ರ ಆಸರನ್ನು ಬರ್ಲಿಲ್ಲ. Now what is the share to be altered? ಕೊಡಮ್ಮ. ಅವ್ರ ಆಕ್ಷನ್ ಬ್ರೋಕರ್ ಮೇಲೆ ಅಷ್ಟೇ. ಹೋದ್ಸತಿನೂ ಅದೇ ಹೇಳಿರೋದು. ನೀವು ಬರೇ ಯು ಅಪಿಯರ್ ಫಾರ್ ಸ್ಟಾಕ್ ಎಕ್ಸ್ಚೇಂಜ್ ಅಂಡ್ ಈವನ್ ದಟ್ ಈಸ್ ನಾಟ್ ದೇರ್ ನೌ ಇನ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್. ಅದೇ ಕೇಸ್ ತಾನೆ ಇದು. After 10 years also I'll remember. All right, heard say G. Krishnamurthy, Learned Senior Counsel, Vivek Holla, and who else for the appellant? Rajashri for illa ಇವರೇ ಇದಾರಲ್ಲ, ಸಾಜಿ P. John, Sri Bapat Posta. Contesting respondent plaintiff. Contesting respondent dash plaintiff is represented by Sri Satyanarayana Gopal. Satyanarayana Gopal Rao not present. In order to facilitate Sri Satyanarayana Gopal Rao to address the arguments, release this matter on 31/10 at 2:30. Mallikarjun Reddy. ತಾವು ಯಾರಿಗೆ? Yes. Who is for the other side? Served and unrepresented. Yes, please. Why suit came to be dismissed, Mr. Sebastian? Not properly? How come? How come? What is your memorandum articles of association would permit whom? Director or company secretary or the managing director? Yes. Yes. Yes, order 29. You have produced that copy? Now only on that ground you are non-suited, therefore the suit has to. That's okay. Now if you are non-suited on the ground of Delhi High Court judgment on order 29, that has to be set aside and matter has to be remitted for consideration on merits. Now what is the finding on merits? On merits, what is the contention? What is the original contract? Where is the original contract? Stage, when it should be done? No such contract details are forthcoming in your exhibit P1. Nothing is there when you should commence, when you should do, whether the civil work to be completed, all these things, nothing is there. Nothing is there. My exhibit P7 is the answer for your contention. You have terminated your contract much earlier to your suit. That's why I said matter, I'll send it back if they want. No, the question is, you have supported a decree for which there is no material. Now, if I want to decree, there is nothing on record to show that, when you are required to commence the work, when you are required to complete the work, nothing of that schedule is forthcoming. No, you are the one. You are the one who has to say, that this was dismantled. You have led the evidence, but they have also led the evidence. Only oath against oath, no documentary evidence. Only oath against oath. You also say it has been done, they also say it has not been done. They have also alleged the same thing to you. See, exhibit P1 is given a go by. In the place of exhibit P1, exhibit D1 has been come into picture. Your client admission. So exhibit P1 is not acted upon. Instead, exhibit D1 is the one which has been to be looked into. Exhibit D1, you see, that has been admitted by your client in the cross examination. Look at exhibit D1. Your exhibit P1 is not accepted by the defendants. So therefore, in the place of exhibit P1, D1 has come into picture. In other words, it is as per the exhibit D1 you are required to work, not as per exhibit P1. Is it not? No, sir. Sorry. I think you are not fully prepared with the brief. D1 is the modified contract, which has been the quotation, which has been accepted by the plaintiff company. You sent exhibit P1. That was looked into and then said that it is not going to work in that fashion, and exhibit D1 was given by the defendants, which was accepted by plaintiff company. Modifications are carried out as per that. That has been relied upon. See, 4 to 6 weeks was what was the time that was stipulated as per exhibit D1. That was in June. So July or maximum mid-August it should have been there. Now when actually the things are supplied is in September. So there is a delay of 1.5 months. Now this is what has been there. No, your client has stated that he could not deliver the goods though it is fabricated because the civil work was not complete. But your client admits that your PW1 admits defendant did not inform me in writing stating that his site is not ready to install the prefabricated steel materials, but it informed me orally. The work was not completed within the stipulated time as the defendant did not keep the site ready for receipt of my materials. Defendant has not informed me in writing to remove the installed steel structure in order to plaster and therefore so and so. I told the defendant that it is impossible and risky to remove the structure already fixed, and defendant has removed the structure on their own, cutting it. It is not true to suggest that defendant has not asked me to remove the structure. I do not know the name of the agency appointed by defendant to cut open the structure and remove it. There is no written communication to me by the defendant to refix the structure. It was a oral communication. Cost of repairing, refixing the structure was estimated at rupees 50,000 on the basis of the assessment of fabrication labor required to fix the structure, including the clamps and accessories. Defendants orally agreed to make this payment. Who will believe all these things? Such a huge structure. How can defendant cut by himself? That is where the problem is. Anyway, if you are comfortable, I am remitting the matter to the trial court because the other side is not there on the ground that suit could be maintained. The fact that the Delhi High Court ruling is overruled by the Supreme Court and the matter to be reconsidered. Otherwise, will you argue on merits, will dispose of. Now itself. All right. All right. You pass on that judgment on that issue, I will at least hold in your favor. You have that judgment? Please. No, it's not available on record. Regard. Padama idre. Heard Sri Sebastian. No representation on behalf of the respondents. Appeals stood dismissed as against the second respondent. No representation on behalf of respondent and appeal stood dismissed as against the second respondent. First, Netpara. The present appeal is filed challenging the validity of the judgment and decree passed in OS number 918 of 2002 on the file of Additional Civil Judge Senior Division, Additional City Civil Judge Bangalore, dated 14th December 2006, whereby suit of the plaintiff came to be dismissed. First, Netpara. Brief facts. Parties are referred to as plaintiff and defendants for the sake of convenience as per their original ranking before the trial court. Brief facts which are utmost necessary for disposal of the appeal are as under. First, a suit came to be filed by the plaintiff company for recovery of sum of rupees 1,25,000 with interest at 18% per annum from the date of suit till realization. First, plaintiff contended that plaintiff is a private limited company registered under the Companies Act 1956 and has been carrying on the business of fabrication and erection of pre-engineered steel buildings and mezzanine floors. First defendant engaged the services of the plaintiff to erect a space-framed structure for a project at Coimbatore Nagar Double Road, opposite to petrol bunk, Vishwamanava Road, Mysore, for their undisclosed principal and plaintiff's quotation dated 2/6/2000 was accepted by the first defendant by their letter dated 21/6/2000. Defendant also made certain modification with regard to the terms and conditions of the quotation while writing the letter on 21/6/2000. Next para. First defendant paid a sum of rupees 2 lakh as advance, and on 2/9/2000, the plaintiff informed the first defendant that all the fabricated materials were ready for dispatch and requested to make payment of 45% of the cost. Defendants accordingly paid a sum of rupees 2,25,000 being the amount of 45% of the cost of the work. After receipt of said 45% of the cost, after receipt of the sum of rupees 2,25,000, plaintiff dispatched the fabricated materials. According to plaintiff, the erection of the fabricated materials got delayed due to non-completion of the civil work. The structure could not have been erected until all the beam work was completed. Beam work was completed. It is further contended by the plaintiff that the erection was further delayed on account of delay in plastering the walls, and it was agreed that after the completion of the plastering of the walls, the plaintiff would erect the fabricated material. Next para. Defendant demanded the plaintiff to dismantle and remove the work already completed so that they could complete the plastering. However, plaintiff informed the defendants that removing of the fabricated structure would result in damage to the structure and therefore denied the request of the defendants. Further, defendant engaged services of yet another agency and got the fabrication work dismantled and later on completed the plaster work and requested the plaintiff to refix the fabricated work, and plaintiff agreed to do so by collecting on payment of rupees 50,000 as additional cost by letter dated 6/12/2000. Plaintiff further agreed to refix the fabricated material and incurred additional cost in a sum of rupees 50,000 and therefore demanded the balance sum of rupees 1,25,000 by notice dated 3/1/2001. Next para. However, after the completion of the work, the defendants demanded extra clamps and fixtures which was not originally included in the contract, and plaintiff informed the defendants by letter dated 21/2001 that it could be provided if payments are made as per the demand made by the plaintiff. Next para. Defendant also contended that the plaintiff also contended that the delay in completion of the work is due to the laches on the part of the defendants and for which the plaintiff is not responsible. Despite demanding the amount, when the defendants failed to make the payment, the plaintiff was constrained to file the suit for recovery of sum of rupees 1,25,000 with interest at 18% per annum. First, next para. In pursuance of the suit summons, second defendant filed written statement and first defendant filed a memo adopting the written statement filed by the second defendant. Next para. The contents of the written statement of the second defendant in brief is that the suit is wholly misconceived and the delay has occurred on which is attributable to the plaintiff, and defendants are actually put to loss by the delayed erection of the space frame, and therefore, sought for dismissal of the suit. Next para. It is also contended that cost of the work entrusted to the plaintiff was rupees 5 lakhs, and plaintiff assured the defendants that project, including the delivery of the materials and erection space, would be completed within 4 to 6 weeks. But the order to commence the work was given to the plaintiff on 8/6/2000, and actually the project was to be completed on or before 23/7/2000. But the plaintiff delayed in executing the work. As such, defendants were put to loss and sought for dismissal of the suit. Next para. Based on the relevant contents of the parties, the learned trial judge raised the following issues. Next para. In order to prove the case of the plaintiff, director of the plaintiff, Sri S. Santosh got examined himself as a PW1. Managing director of the plaintiff by name S. Santosh got examined as PW1 and relied on 11 documents which were exhibited and marked as exhibit P1 to P11, comprising of copy of the quotation, acceptance letter, correspondence, and letter of the first defendant dated 1/2/2001, fax copy of letter dated 9/2/2001, copy of the letter dated 15/5/2001, and office copy of the legal notice. As against the evidence placed on behalf of the plaintiff, second defendant KB Nagendra got examined himself as DW1, and he has relied on 10 documents which were exhibited on marked as exhibit D1 to D10, comprising of quotation, letter addressed by the plaintiff to first defendant, letters addressed by the plaintiff to first defendant and first defendant to plaintiff, fax transmission report, bills given by DW1 to some other contractors, checks. Next para. On conclusion of the recording of the evidence, the learned trial judge heard the parties in detail and dismissed the suit of the plaintiff by holding that there was a delay on the part of the plaintiff in executing the work, and also the suit is not maintainable as it was not properly filed by the company as per order 29 CPC. Being agreed by the same, the unsuccessful plaintiff has filed the present appeal on the following grounds. Next para. Sri M.A. Sebastian, learned counsel for the appellant, reiterating the grounds urged in the appeal memorandum, contended that the learned trial judge has wrongly answered the issue number 3 by placing reliance on the judgment of the Honorable High Court of Delhi reported in EIR 1991 Delhi, page number 25, as referred to by the learned trial judge in paragraph number 21 of the impugned judgment, and sought for allowing the appeal. He also pointed out that the question of delay cannot be attributed to the plaintiff, inasmuch as the civil work was not completed at the site in Mysore and the fabricated materials were delivered after the completion of the civil work, and even after the fabrication material was delivered at the site, the same could not be erected on account of want of plastering to the walls, and therefore, the delay, if any, is attributable to the defendant, which was not properly appreciated by the learned trial judge in the impugned judgment, resulting in miscarriage of justice, and therefore sought for allowing the appeal. Next para. In view of the contentions urged on behalf of the appellant, and in the light of the appeal grounds, This court perused the matter law on record meticulously. On such perusal of the matter law on record, following points would arise for consideration. Whether the dismissal of the suit by the learned trial judge, placing the reliance on the judgment of the Honorable High Court of Delhi in AR 1991 Delhi, page 25, is just and proper. Whether the plaintiff has made out a case that he is entitled for it is entitled for sum of rupees 1,25,000 with interest at 18%. More, whether the impugned judgment is suffering from legal infirmity or perversity. Next, what order? Next para. In order to answer the first point, comma, the learned counsel for the appellant has placed the reliance on the following judgments. Following judgment of the Honorable Apex Court. In the case of United Bank of India, the birth body. In the case of United Bank of India and Naresh Kumar and others, the Honorable Apex Court has held as under relevant para on mark ಮಾಡ್ಸ್ಕೊಂಡ್ರೆ. ಆಯ್ತಾ? relevant para ಮಾಡ್ಸ್ಕೊಂಡ್ರೆ. Next para. This court perused the judgment of the Honorable Apex Court on the issue. Next para. Admittedly, comma, since this plaintiff company is represented by the managing director and plaintiff is signed by the managing director Sri Suresh, comma, Sri Santosh, comma, there is sufficient compliance of Order 29 CPC and the same has not been properly appreciated by the learned trial judge in the impugned judgment by placing the reliance on the judgment of the Honorable High Court of Delhi in AR 1991, reported in AR 1991, Delhi 25 in the case of Messrs. Nibro Limited versus National Insurance Company Limited, and accordingly, comma, the answer on issue number 3 in the impugned judgment, accordingly, comma, the trial court holding issue number 3 in the negative is thus needs to be interfered by this court, and accordingly the issue number 3 accordingly, comma, point number 1 is answered in the affirmative. Next para. Aita? Affirmative alla. Now whether the right anta ತಗೊಂಡಿದ್ವಿ ಏನು issue number point number 1 ಏನು ತಗೊಂಡ್ವಿ? Whether ಅಂತ ತಗೊಂಡು negative. Correct ಆಗಿದೆ. Negative. And suit is maintainable. First, next para. This would take this court to the next point, whether the plaintiff has made out a case for recovery of sum of rupees 1,25,000 with interest at 18%. First, in the case on hand, comma, defendant number 1 placing the order for fabrication of the material, fabrication of the space ಎಂತದ ಹೇಳಿದ್ನಲ್ಲ, so and so with the plaintiff, ಆಯ್ತಾ, with the plaintiff, ಆಯ್ತಾ, space framed structure with the plaintiff for and on behalf of the second defendant is not in dispute. First, however, according to the plaintiff, comma, the contract was concluded as per exhibit P1. First, PWN in his cross-examination categorically admitted that exhibit P1 was not accepted by the first defendant, and in the place of exhibit P1, comma, modified contract by exhibit D1 was accepted by the plaintiff company. First, next para. Exhibit D1 reads as under. First, next para. As could be seen from the exhibit D1, comma, and the exhibit D1 and the ಯಾವ್ದು ಬೇಡ ಅದನ್ನ ಇಂಟು ಹಾಕ್ಬಿಡು, and the time limit that has been fixed in the for completion of the project is 4 to 6 weeks from the date of placing the order. In the case on hand, comma, there is no dispute that the order was placed on 8/6/2000. However, according to the plaintiff, it was accepted on 21/6/2000. First, even assuming that the order is to the contract work is to commence from exhibit from 21/6/2000, 4 to 6 weeks would end in mid August 2000. First, admittedly, the fabricated materials were not delivered in the site of the in the site of the second defendant, where the construction was being carried on in mid-August 2000, and the same was delivered in the month of September, that is 3rd September 2000. First, note, in order to explain the delay of 2 weeks, plaintiff has come out with a theory that the civil work was not completed in the site. Therefore, there is a delay. First, PW1, who is the managing director of the plaintiff, has clearly admitted in his cross-examination that the delay in completion of the civil work was not intimated to the plaintiff by the defendant in writing. First, further, according to the plaintiff, he had received 45% as per the 45% of the project cost as per the exhibit D1, and thereafter, the delivery has been made. First, having received the sum of rupees 2,25,000, which is representing 45% of the total cost as per exhibit D1, plaintiff should have completed the erection of the fabricated material on the site. First, however, plaintiff postponed the erection of the fabricated material on site on the ground that the plastering work of the wall was incomplete. First, except the oral testimony of PW1, there is no material on record to establish the said aspect of the matter. First, PW1 categorically admits that the defendant has not informed that the civil work was not complete in writing to the plaintiff. First, next para. Further, it is the case of the plaintiff that defendants requested to dismantle the fabricated work so as to facilitate the plaintiff to, so as to facilitate the defendants to complete the remaining masonry work. First, in respect of said request also, there is no documentary evidence on record except the oral testimony of PW1. First, further, according to the plaintiff, defendants engaged the services of some other agency and got dismantled and wanted the plaintiff to refix it, and plaintiff agreed to refix it on payment of rupees 50,000 as additional amount. First, even with respect to this modified portion of the contract, there is nothing in writing. First, next para. When all other project work was completed, was agreed to be carried out based on the written communications and the quotation given by the parties, in respect of the additional work, plaintiff agreeing to carry out the same on a oral contract cannot be countenanced in law, and the said aspect of the matter has been rightly appreciated by the learned trial judge while appreciating the oral testimony of PW1 vis-a-vis the oral testimony of DW1 and the material evidence on record. First, taking note of these aspects of the matter, this court is of the considered opinion that the plaintiff has failed to make out a case that he is entitled to sum of rupees 1,25,000 with interest at 18%. What was the amount due? Minus 50,000. No, 50, leave it. What was the remaining amount? Not 75. They have paid 225, no? Total 5 lakhs. 2 lakhs he had received. 425, how much amount? 425 was received. So now only 75,000 was remaining. Even that they did not pay. All right, first, even according to defendant number, even according to DW1, the total payment made to the plaintiff is only to the extent of 4,25,000. First, what are the steps that has been taken by the defendant in order to get the work completed at an early date is also not forthcoming on record. Taking note of the fact that Exhibit D1 is confronted to PW1 on behalf of the defendants and the same is accepted by the PW1, the plaintiff would be entitled to balance sum of rupees 75,000. However, if there is a real loss that has been caused to the defendant for the alleged delay of 2 weeks, for delay of 2 weeks in as much as the fabricated materials were delivered on 2nd September 2020, 2nd September 2000, 3rd September 2000, entire 75,000 would not have been detained by the second defendant. First, next para. In the absence of any cogent evidence placed on record as to what is the actual damage that has been suffered by the defendant for the delayed erection of the fabricated material, and when plaintiff has also tried to justify the delay by putting the blame on the defendants, this court is of the considered opinion that if sum of rupees 25,000 is ordered to be deducted from the balance sum of rupees 75,000 as per Exhibit D1 that the plaintiff is entitled, the ends of justice would be met. Accordingly, the plaintiff would be entitled to sum of rupees 50,000 with interest at 6% per annum, 6% per annum from the date of the completion of the work from the date of suit till realization. First, accordingly, point number 2 is answered partly in the affirmative. Next para. In view of the finding of this court on point number 1 and 2 as above, regarding point 3 tako. In view of the finding of this court on point number 1 and 2, to the extent that the suit is dismissed as not maintainable and the dismissal of the suit in entirety in the impugned judgment in the considered opinion of this court is thus suffering from legal infirmity and perversity. Accordingly, point number 3 is answered partly in the affirmative. First, in view of the regarding point number 4, in view of the finding of this court on point number 1 to 3 as above, following order is passed. Appeal allowed in part. Suit is decreed in a sum of rupees 50,000 with 6% interest on the date of suit till realization with proportionate cost. That much I could do. Your fairness. Honestly, initial, I understand. No, your fairness is honestly appreciated by the court is what I am trying to communicate to you. Yes, please. Kodi. Signed by bank, is it? Who else remains? Or yaro service act bandilwa? All right. Memo of calculation filed on behalf of the first respondent bank. According to memo of calculation, another 3 into Madivare, 28,07,513 is the amount due to the bank on account of the mortgage created by Yaro. Respond number 4 with the first respond bank. First, next para. Iburdu Bardbudi, Yaridar, who are the mortgages? Loni Yaro. 3 and 4. First, next para. Appellant present. Where is the appellant? Appellant present. So also the manager, branch manager, ikkada bani. What's your good name? Whatever it is, what is his operation manager? Entado? Branch operation manager. What's your name? Shashank present. First, a joint memo is filed by appellants. Ibru idar appellants antadidiri. Obre idaralla. Okay. ನೀವು ಅಪಲೆಂಟ್ಸ್ ಅಂತ ಯಾಕೆ ಹಾಕ್ತೀರಿ? First appellant and the branch operation manager of the first respondent. First up. Advocate for appellants and respondent number 1 have signed the joint memo. Joint memo reads as under. In view of the joint memo, first up, next para. Aita. In view of the, as per the joint memo, comma, DD in a sum of rupees, DD na, DD in a sum of rupees 28 lakhs, so and so, is paid by the appellants in favor of the first respondent bank. First, next para. After payment of the sum of rupees 28 lakhs, so and so, comma, the appellants who are the subsequent purchasers of the property which has been mortgaged by the respondent number 3 and 4 in favor of the first respondent, comma, are entitled to recover the said sum of rupees 28 lakhs so and so by exercising the rights of the first respondent bank as assignee mortgagee as against respondent number 3 and 4, including the sale of the mortgaged property. First, after receipt of the sum of rupees 28 lakhs so and so, comma, bank shall execute a letter in favor of the appellants herein that their dues are satisfied in toto and all the rights that the first respondent bank possessed in respect of the mortgage property is transferred on to the appellants jointly and return the original documents held by them which has been delivered to the first respondent bank at the time of mortgage to the appellants. First, ordered accordingly, office is directed to all ordered bada. Next, office is accordingly following order. Aita, appeal stand disposed of in terms of the joint memo. Office is directed to pass a modified decree in terms of the joint memo, appending the copy of the joint memo as part of the decree. No order as to cause. ನಾನು ಇವಾಗ ಆರ್ಡ್ರೇ ಬರೆದು ಬಿಟ್ಟಿದ್ದೇನಲ್ಲ, ಅವ್ರು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲ, ಇಟ್ಸ್ ಎ ಡೈರೆಕ್ಷನ್ ನೌ. I have given you what more than what you have asked for. ಆಯ್ತಲ್ಲ, ಮುಗೀತಲ್ಲ ಈಗ. ಎಲ್ಲಿದೆ? ಅವ್ರು ತಾನೇ ತಗೊಂಡು ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ, ಅಲಾಂಗ್ ವಿತ್ ದಿ ಲೆಟರ್ ಕೊಡ್ತಾರೆ. ಅಲ್ಲಿ ರಿಕವರ್ ದಿ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಅಮ್ಮ, ಇಲ್ಲಿ ಈ ಕಡೆ ಎಂಟೈರ್ ಅಮೌಂಟ್ in the same proceedings. Ask. You may file an execution against respondent number 3 and 4. Bring the property for the sale. Ask. ಕಲಾದ್ಗಿ ಆಯ್ತಾ? ಅದು ಆಯ್ತು. ರಘುನಾಥಾಚಾರ್ ಅವ್ರು ಇಲ್ಲಮ್ಮ, ಅವ್ರು ತೀರ್ಕೊಂಡೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಇಬ್ರು ತೀರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವ್ರಿಲ್ಲ ಈಗ. It is submitted that Sri M.E. Raghunatachar and Sri M.R. Vijay Raghavan are no more. Hence issue court notice to the appellant. Issue court notice to the appellants. Okay. Why? Let him appear through VC and argue the matter. We have given this facility, no? Let him come and argue. ಎಲ್ಲಿ ನೆನ್ನೆಗಿತ್ತಲ್ಲ ಆ ಮ್ಯಾಟ್ರ್ ಇದು, ಅದೇ ತಾನೆ? ಎಲ್ಲಿ ಪರಮೇಶ್ವರಪ್ಪ, ಮುನಿಯಪ್ಪ, ನಿನ್ನೆ ಏನಾಯ್ತು ಆರ್ಡ್ರು? ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆಯಾ? ಪರಮೇಶ್ವರಪ್ಪ, ಪಾಸೋರ್, ಅಮರೇಶ್ ಅಂಗಡಿ, where is ಅಮರೇಶ್ ಅಂಗಡಿ? ಏನಿದು? Let me see what it is. You are the decree holder. Dismissed. Then why do you want after vacation? On what ground it has been dismissed? On what ground, Badri? You have not read the papers. Truth is decreed, sir. That's what I am trying to say. You made a wrong submission. ಇರ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಅದೇ BBMP ಇದು. ಹೌದೌದು. ಆಫ್ ಮಾಡಿದ್ರೆ ಬರಲ್ಲ. ಈ ಇದು ಏನು ಎಂತದದು ಸೈಲೆಂಟ್ ಮಾಡಿದ್ರೆ ಬರುತ್ತೆ. No, sit down. ನೀವು ಒಬ್ರೇ ಅಲ್ಲ. This is I think half a dozen time that today. No, all are alert. All are alert. All are alert. Suit is decreed in 1/6 share. Suit is decreed in 1/6 share. So that is the wrong anta aur barta iradu. Let us see how it happens. None present on behalf of the appellant or Badrinath for R1 to R5 present. Post after vacation. Pradeep. C. Pradeep. None present on behalf of the parties. Post after vacation. Srinivas. ಸರ್ ಕೇಳಿದ್ವಲ್ಲ ಅದವತ್ತು, ಅದೇ ಮ್ಯಾಟರ್ ಅಲ್ಲ ಇದು. ವೇರ್ ಇಸ್ ಮಿಸ್ಟರ್ ಶ್ರೀನಿವಾಸ್? ಬರ್ಲಿ ನೋಡೋಣ. ಮನಿ ಡಿಗ್ರಿನೋ? ವಿಲ್ ಫೈಂಡ್ ಔಟ್ ಸಮಥಿಂಗ್ ಕುಡ್ ಬಿ ಡನ್ ಟುಡೇ. ಭಟ್ರೆ ಬನ್ನಿ, ಬಾಳಿಗ್ರೆ ಬನ್ನಿ. ಎಸ್, ಬರ್ಕೊಳ್ಳಿ. ಪಾರ್ಟಿಗಳು ಬಂದಾರಾ? ಅಪಲೆಂಟ್ ಪ್ರೆಸೆಂಟ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸಿ BM ಬಾಳಿಗ present. First, a joint petition is filed, signed by advocate for appellant and advocate for respondent. First, Sri BM Baliga submits that respondent is unable to appear before the court even for the execution of the compromise petition as because of his old age. All right, as he is having some personal inconvenience. Post next para. He further submits that respondent has authorized. ಇಲ್ಲಿ ಬರ್ತಾರಾ? ಅಲ್ಲ, ಇಲ್ಲಿ ಬರ್ತಾರಾ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ? ಅದೇ ಅಂತ ಒಂದು. ಆಯ್ತು ಬಿಡಿ, ಅದಕ್ಕೆ ಕೇಳಿದ್. ಆಲ್ ರೈಟ್. He has authorized him to enter into compromise. Post next para. The parties have settled the dispute amicably and presented a joint memo. Joint memo reads as under. Next para. In view of the joint memo, following order is passed. Appeal stand disposed of in terms of joint memo. Office is directed to pass a modified decree in terms of the joint memo, appending the copy of the joint memo as part of the decree. All right, full stop. Next for ಅದೇನೇ ತೊಂದ್ರೆ ಇಲ್ಲ. Appellant is entitled to, respondent is entitled to sum of rupees 3,43,388 as per the decree. And amount in deposit to the extent of 3,43,388 is ordered to be withdrawn by the respondent under due identification. Full stop. Balance amount, if any, in the account. Balance amount, if any in the account, comma, is ordered to be withdrawn by the appellant. And since the matter is settled amicably between the parties, appellant is also entitled for refund of permissible court fee. Virupakshaya.
It's an IFF for the respondent.
ಏನಾಯ್ತು ನೋಡಿ. Counsel for appellant has filed a memo. Memo reads as under. In view of the memo, appeal stand dismissed with liberty as prayed for. No address to cast.
Great. IFF for the respondent.
Chidanandaya, Chandrachud. Awaiting the notice of R1G, proposed R1G 3 and 4, release this matter, these matters on 3/11. Chandrachud, ಆಯ್ತಲ್ಲ ಅದೆಲ್ಲ. Yes, please. ಆಯ್ತು ಅವ್ರು ಹೇಳಿ. Somebody has moved an adjournment in the morning. You'll have to blame your brother. What urgency? Now the roast is continued. You argue after vacation. ನಾವು ಕೇಳಿದ್ರು ನಾನು ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಅವ್ರು ಯಾರು ಹೇಳಿಲ್ಲ ಈ ತರ ಹಿಂಗಾಗಿದೆ ಅಂತ. ಎಲ್ಲ ಅದು ನಿಮ್ಮ ಸ್ನೇಹಿತರದ ದುರ್ಬುದ್ಧಿ. ನಾನೇನ್ ಮಾಡೋದು ಅಲ್ವಾ? Correct, we'll do it. You make a mention soon after the vacation. We'll list it. ಅದಕ್ಕೆ ನಾ ಬೆಳಗ್ಗೆ 4 ಸತಿ ಕೇಳ್ತೀನಿ ಯಾರು ಏನು ಅಂತೆಲ್ಲ. ಬಂದ್ರು ಕೇಳಿದ್ರು ಹೋದ್ರು. ಹಾರ್ನಳ್ಳಿ pass over. We'll consider he only is seeking for a Passover. No. ಅಲ್ಲ ಅವ್ರ ಅಡ್ಜರ್ಮೆಂಟ್. No, ಶೇಷಾದ್ರಿ ಅವರೇ ಅವರು ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಬರ್ಲಿ ಅವ್ರೇನ ಪಾಸ್ ಓವರ್ ಕೇಳ್ತಾರೆ. Though I was informed about the roster being continued, I kept it secret. No, I mentioned it in the sometime earlier that corridor talks are that I am continued anta, but I was bandralla bani. All right, Sri Ashok Harnalli, learned senior counsel, and Sri Sheshadri, learned senior counsel, represent the parties. at request of both, release this matter on 9/11. Rahmatullah Kotwal. Request of counsel for appellant time period post after vacation. ನೋಡಿ ಅದೇನಿದ್ರೆ ಮಾಡಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಷ್ಟೇ. 15ಗೆಲ್ಲ ಡೇಟ್ ಯಾಕೆ ಕೊಡೋದು? 15ಗೆಲ್ಲ ಡೇಟ್ ಬೇಡ. People are waiting from 2005. It will be listed, don't worry. Ravi Prakash 61. Ravi Prakash. ಯಾಕೆ 61 Ravi Prakash. Ravi Prakash, CM Desai, none present, urgent. Passed over. ಅಷ್ಟೊತ್ತು ಕೊಟ್ರೆ ಸರಿ ಇಲ್ದರೆ ನೋಡೋಣ. Where are your friends? Where are your friends? That's why I said both of you don't want the matter to go on. You are ready, but where are your friends? They filed, for vacating the interim order, and they are not ready. We'll take it up at 2:30. We'll find something to work out. What is happening? What is the scope of the suit?
Like serial of 28, then number 2 was distributed.
What is the product?
When 2009 had 5 payments. So started it was 19. It had a patent. Record number 2 was mine.
ಚಲೋ ಆಗಿದೆ. 2 ಏನು? Just a minute. 2 ಏನು? 2, 3 ಎಲ್ಲ ಅಲೋ ಆಗಿದೆ. So what is remaining is only 4. IA1, IA4 and IA9. Yes. No, it's all over now. Yes.
Further is mostly different number 1. My patented product. He uses my patent, points my patent A into this product and that's market. That's when I have taken to hold it for the 19 and That's the patent required. Government will issue under Kind of those. Because based on law. Situation of the grant of payment. Created assignment agreement where all the rights created.
Now, when did you file this application for taking action for violation? No, date. 18 to June 2019. No, they have not filed objections for that. Barkoli. Which is that application? Which is that application you filed?
My lord, I appear for the respondents in this matter.
Yes.
My lords, I seek for a short accommodation, please, my
No,
lord.
no.
My lords, there is some inconvenience, my lords. Any short accommodation, please, my lords.
Why should I? Morning
My
it
lord,
was made known that you should argue. Your friend
Yes,
is
my-
here, is arguing.
Yes, my lords. Kindly give a short accommodation, my lords.
Why should
Even
I give you the
tomorrow-
question?
My lords, there is
Applications
some-
are pending since 4 years.
I
And when
understand.
the matter to go on,
I understand, my lords. I completely understand and bow down for my lords, my lords. But kindly a short accommodation, please.
no, please understand why the application should be pending for 4 years.
I understand, my lords. Will
You
file
don't sell,
a.
no, that's all. Very simple point. If you are not violating this patent, make a statement that I am not violating, that's all. With that undertaking, IA 1 and 9 could be disposed of. The remaining application is if you have violated in between. If you have
My lord-
violated in between, an inquiry will be held by the registrar judicial. Then we can go ahead with the suit.
My lords, senior is held up, my lords. A short accommodation,
Your is distributor. You are not the inventor of the product.
please, my lords.
Then how can you make use of it?
My lords, there is some technicalities that we'll have to look into, my lords. Any short accommodation,
What
any dates, my-
technicality? All those, unknown things will not help here.
Please, my lords, any short accommodation, please.
What is that? Some inconvenience, some technicality. You come out with that technicality. What is the technicality?
The senior is out of station, my lords.
That is not a technicality issue. It's a
I
personal
can't-
problem of yours.
I completely understand, my lords. I completely
Then why do you
understand.
say some technicality? What is the technicality involved in an adjournment?
My lords, we'll have to look into the matter with respect to that.
Who prevented you? It's your brief.
I understand,
You
my
are
lord.
looking into that brief since 2019.
Please, my
For
lords.
this court, this is the first time that the matter is listed. Court is
Exactly.
ready. You are not ready.
My lords, any short accommodation, please, my
No,
lords.
it's
Any
all
date
about,
we'll-
it's all about a boxer type panty that has been designed and patented by the plaintiff. You, being the distributor of that particular apparel, took note of all those things, knew the know-how of that particular product, later on started your own company and claiming to be the, whatever be the patent that has been used as yours. It is per se wrong. That's all the crux of the matter. Nothing more, nothing less.
My lords, I understand, my lord.
You don't
Senior.
you make a statement, I don't use, there ends the matter. With your undertaking, I'll close the suit. Why should you waste further time on that? Anybody can invent anything. You show that your product is different and their product is different. You can still keep on selling your product. Their product will also be sold in the market. As simple as that. If you want to have a different product, slightly different also, permissible.
Yes, my lords.
That's all, no? Come in the afternoon at 2:30 and make a submission with regard to the pending IS. I was about to dictate.
My lords, kindly, my lords. Senior has asked for a slight accommodation, my lords. My lords, any date, my lords, please.
No, when the court was about to dictate, you came online. Till
My
such
lords,
time
that-
you were watching the proceedings.
No, my lords, I was just appearing, my
No,
lords.
sorry. All those
My
things will not be entertained in this court. Court knows very well.
May I completely understand, my lords. Any short accommodation, please.
No accommodation for what? Why should I accommodate? I'll, if you have violated the order, you can prove it. If you don't violate the order, that will be recorded by the registrar judicial for facing an inquiry. Why should have any accommodation? I'm only referring the matter for inquiry to the registrar judicial.
My lord, senior is out of station, my lords. We'll make hearing
What
on
is
all
it
the
your senior can do if I order for inquiry? Should I dispose of on the merits without there being report from the registrar judicial on 39 rule 2A? I'm asking you to go and lead the evidence, that's all. Barkoli, what's your good name? Wait, mister, what's your good name? Pranav Kumar, what is your name? Akshata.
Yes, ma'am.
Sri Pranav Kumar and Akshata for the parties. Application IA4 of 19 is filed to initiate appropriate action for the violation of the injunction order passed ex parte on IA1 of 1919, IA1 of 19 dated IA1 of 19 order, first order. June 2019, first time. The application is objected by filing a memo stating that contents of the return statement. That's what. The application though filed on, when did you file? 18/6/2019. A4. I4 is filed on what date? 16/7/2019. Enantavantama. He is not objected to by the contesting respondents, contesting defendants till today. First. Anyway, whether the defendants have violated the order of injunction granted on 25 so and so referred to Supra or not is a matter of inquiry, and the same needs to be inquired into. First, accordingly, IA4 of 19 is referred to registrar judicial for inquiry and filing appropriate report. First, parties are directed to appear before the registrar judicial for the purpose of inquiry without further notice on 26/10/2023 at 11:30 AM. (26/10/2023) at 11:30 AM. They will get it, registrar judicial will get it. That's all on the merits. Now it is only question of IA4 inquiry. Yes, you appear before the registrar judicial on 26/10/2020 for the purpose of inquiry on IA4.
Yes, ma'am.
That's already granted till further orders, no? Then why should I extend? No, when is there an order limited? Interim order extended until further orders. Until further orders, yes. Yes. Next. ಏನಾಯ್ತು ನಾಗರಾಜು? ಕೊಡಿ ಮತ್ತೆ ಅದನ್ನ ಸರ್ವೆ ನಂಬರ್ 1 ಕರೆಕ್ಷನ್ ಮಾಡಿ ಮುಗಿಸೋಣ. ಇವಾಗ ಹೋಗ್ಲಿ ಬಿಡ್ರಿ, ಫಾರ್ಮೆಟ್ ಎಲ್ಲ ಕಟ್ಕೊಂಡು ಏನಾಗಬೇಕು. ಇವಾಗ ಯಾವ ನಂಬರ್ ಸರ್ವೆ ನಂಬರ್ ಏನಾಗಬೇಕು ಹೇಳಿ. Item number 1 ಅಲ್ಲಿ 11/5 ಆಮೇಲೆ ಹ್ಮ್ 216 ಅಷ್ಟೆರಡು ಆದ್ರೆ ಮುಗಿತಾ ಬರ್ಕೊಳ್ಳಿ. ಎಲ್ಲ ನೀವು ಅಲ್ಲಿ ಫೈನಲ್ ಡಿಕ್ಲೇರ್ ಕೇಳ್ಕೊಳ್ಳಿ, ನಾನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇಲ್ಲಿ ನನ್ನ ಹತ್ರ ಏನಿಲ್ಲ. ಒಳ್ಳೆ ಚೆನ್ನಾಗಾಯ್ತಲ್ಲ, ಬರ್ದೇ ಇದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ? ಅಷ್ಟೇ ಮಾಡಿ ತಗೊಳ್ಳಿ, ಅದೆಲ್ಲ ನಾನೇನು ಬರೆಯಕ್ ಹೋಗಲ್ಲ. ಅವೆಲ್ಲ ಏನು ಹೊಸದಾಗಿ ಏನು ಹೇಳಕ್ ಹೋಗ್ಬೇಡಿ ನೀವು. ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಶ್ರೀ ನಾಗರಾಜ್. ವಾಟ್ಸ್ ಯುವರ್ ಗುಡ್ ನೇಮ್? ವಿಜಯ್ ಕುಮಾರ್ ಫಾರ್ ನಾಗರಾಜ್. ಆಮೇಲೆ BN Muralidhar for R7. No representation on behalf of appellants. Yaru? Who is here? Kariri avarnu. What is his name? Party yaru? Anjappa. Nim lawyer karkonba. ಕರೆಕ್ಟ್. ಅವ್ರು ಬೇಕಲ್ಲ ಯಾರೊಬ್ರು, ಅವ್ರ ಪರವಾಗಿ ಯಾರೊಬ್ರು ಬೇಕಲ್ಲ, ಅವ್ರ ಪರವಾಗಿ ಒಬ್ರು ಬೇಕಲ್ಲ. ನೋಡಿ ಅವ್ರು ಬಂದು ನೋಡಿ, ಆಯ್ತಾ? ವಾಟ್ಸ್ ಯುವರ್ ನೇಮ್ ಸರ್? KJ Jagdish ಫಾರ್ ಅಪಲೆಂಟ್. KJ Jagdish ಫಾರ್ ಅಪಲೆಂಟ್. ಆಯ್ತಾ? ನೆಕ್ಸ್ಟ್ ಪರ. IA 1 of 2021 and 2 of 2021 are filed for recalling the order dated 5/8/2010 with condemnation of delay of 3852 days in filing the application. First, the same are allowed in the interest of justice, having regard to the fact that there is a mistake in the schedule in mentioning the serial number. First, next para. Accordingly, another application is filed under section 152 and 153. Reduce section 6, order 6, rule 7 CPC, rule 17 CPC by the Yashneavaru. By respond number 4, supported by the affidavit of fourth respondent. Elli Neelamma. Neelam Elli. All right. Idare. Aita next para. Perused the same. Next para. In item number 1 of the suit scheduled property, comma, which has fallen to the share of the fourth respondent, which has fallen to the share of 2 to 6. Respond number 2 to 6 and 8. The serial number is mentioned as 169/2, but actually it should have been 11/5. First, so also in respect of item number 4, comma, the serial number is mentioned as 11/5, and it should have been 200 and serial number 216. First, next para. Since the proposed amendment is formal in nature and on account of wrong mentioning of the serial number in the plaint, comma, the fruits of decree could not be enjoyed by the fruits of compromise decree could not be enjoyed by the parties in proper manner, comma, applications filed under section 152 and 153 of the CPC, read with section order 6 rules, read with order 6 rule 7, rule 17 CPC needs to be allowed. Post, counsel for appellant and contesting respond number 7 has no objection to allow the application insofar as the correction of the serial numbers only. First, next para. Accordingly, comma, the application is allowed. Office is directed to pass a modified decree after the plaint is amended. After the plaint is amended by incorporating the serial numbers in the schedule, and also the compromise petition is permitted to be amended with the proper serial numbers in respect of item number 1 and item number 4, as is mentioned in the order. as is mentioned in the today's order. ನಾನೇನು ಮಾಡಲ್ಲ, ಒಳ್ಳೆ ಹೊಸದಾಗಿ ನಾನ್ ಬರಿತಾ ಇದ್ದೀನಿ ಡಿಗ್ರಿನ. ಎಲ್ಲ ಅವತ್ತೆಲ್ಲ ಏನೇನೋ ಮಾಡ್ಕೊಂಡಿದ್ರಿ, ಇವತ್ತೆಲ್ಲ ಮುಗೀತು ಅಷ್ಟೆ. ಆಯ್ತು, ನಾನು ಇಷ್ಟು ಮಾಡಿದ್ದೆ ಹೆಚ್ಚು, ಇವ್ರೆ ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಅವ್ರು ಮಾಡ್ಕೊಡಿ, ಅದೇನಿದೆಯೋ ಮಾಡ್ಕೊಡ್ರಿ. ನೀವೇನು ತಕರಾರು ಮಾಡ್ಬೇಡಿ, ಹೋಗಿ. ಹಾ ತಗೊಳ್ಳಿ. ಅವೆಲ್ಲ ನಾವ್ ಮಾಡ್ಬಾರ್ದು ವಿಜಯ್ ಕುಮಾರ್, ಇದೇ ನೀವು ಹೊಸದಾಗಿ ಹೇಳ್ತಿರಲ್ಲ. ಅವೆಲ್ಲ ಆಗಿದೆ, ಅವ್ರು ಮಾಡ್ಬೇಕು ಅದನ್ನ. ಯಾಕ್ರಿ ಅವ್ರದನ್ನ ಯಾವ್ದ ನೀವು ಅವ್ರದ್ದು ಇಟ್ಕೊಂಡಿದ್ದೀರಿ? ಆಯ್ತು, ನೀವು ಕೇಸ್ ಹಾಕಿ ಟೆನೆಂಟ್ ಮೇಲ್ಗಡೆಗೆ, ಅವ್ನ್ ತಗೋತಾನೆ. ಅವ್ರು ಕೊಟ್ಟಿದ್ರೆ ಅವ್ರ ಹತ್ರ ಒದ್ದು ವಸೂಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಲ್ಲಪ್ಪ, ಪ್ರಶ್ನೆ ಕೇಳಿ ಇಲ್ಲಿ. ಇಫ್ he has received the rent, you institute a suit against that fellow. He will say, I have paid to him. Make him as a witness. He has to say then whether he has paid or not. ತಗೊಳ್ಳಿ ಅಷ್ಟೇ. ನಾನು ಏನ್ ಮಾಡೋದಪ್ಪ, ನಾನಿದ್ನ ಅವತ್ತು ಇಲ್ಲಿ 10 ಸತಿ ಕೇಳ್ತೀನಿ ತಾನೆ, ನಾನು ಕಾಂಪ್ರಮೈಸ್ ಆಗುವಾಗ ಎಲ್ಲ ಸರಿಯಾಗಿದ್ಯಾ ನೋಡಿ ಅಂತ. ಅವತ್ತು ಅದನ್ನ ಮಾಡಿದಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು. ನೀವು ಕೊಟ್ಟಿದ ತಕ್ಷಣ ಇಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಎಲ್ಲದಕ್ಕೂ ಸೈನ್ ಹಾಕ್ಬಿಟ್ಟು ಸಂತೋಷವಾಗಿ ಹೋಗ್ಬಿಟ್ರೆ, ನಾವ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನು ಮಾಡಕ್ ಆಗಲ್ಲ. ಆಯ್ತಪ್ಪ ವಿಜಯ್ ಕುಮಾರ್ ಅವ್ರೆ, ಯಾರಿದ್ರು ಇಲ್ವೋ, ಅವ್ರು ಯಾರು ಬಂದ್ರು ಮಾಡಿದ್ರು, ಯಾಕೆ ಒಪ್ಕೊಂಡ್ರು, ನಿಮ್ ಕಕ್ಷಿಗಾರರು ಇದ್ರಲ್ಲ, ಅವ್ರು ನೋಡ್ಬೇಕು. ಒಂದಿನ ತಗೊಂಡೋಗ್ಬೇಕು ಮನೆಗೆ, ಓದಿಸ್ಬೇಕು, ಕರೆಕ್ಟ್ ಆಗಿದ್ಯಾ ಅಂತ ಕೇಳ್ಬೇಕು, ನೋಡ್ಕೋಬೇಕು. ಇಲ್ಲಿ 10 ಸತಿ ಕೇಳ್ತೀನಿ ನಾನು. ಏನ್ ಮಾಡೋದು ಈಗ? ನಾವು ಕೊಟ್ಟಿದೀವಲ್ಲ, ನಮ್ ಕೋರ್ಟಲ್ಲಿ ಏನ್ ಆತರ ಅನ್ಯಾಯ ಯಾರಿಗೂ ಆಗಿಲ್ವಲ್ಲ. ಒಂದ್ ಕೇಸ್ ಒಳಗಡೆಗೆ ಅವ್ನ್ ಬೇಲ್ ತಗೊಂಡು ಓಡೋಗ್ಬಿಟ್ಟಿದ್ದ, ಮತ್ತೆ ಅವ್ನು ಮಾಡ್ಲಿಲ್ಲ. ಕರ್ಸಿ ಇವಾಗ ಮೊನ್ನೆ ಎಲ್ಲ ಚೆನ್ನಾಗಿ ಬೈದು ಎಲ್ಲ ಹಾಕ್ಸಿ ಒಳಗಡೆ ಹಾಕ್ತೀನಿ ಮಾಡಿಸಿ ಪೂರ್ತಿ ವಸೂಲಿ ಮಾಡಿದ್ವಲ್ಲ, ಕಂಪ್ಲೀಟ್ ಆಗಿ ಸೆಟ್ಲ್ ಆಯ್ತಲ್ಲ. ಅವ್ರ ಮೇಲೆ ಇದ್ದಿದ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್, ಇವ್ರ ಮೇಲೆ ಇದ್ದಿದ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಎಲ್ಲ ಮುಗೀತಲ್ಲ. ಅಷ್ಟೆಲ್ಲ ಕಾಶನ್ ತಗೊಂಡೇ ನಾವ್ ಮಾಡ್ದಾಗ್ಲೇ ಈ ತರ ತೊಂದರೆಗಳಾಗತ್ತೆ. ಅಲ್ಲಿ ವಕೀಲರ ಮೇಲೆ ಪಾಪ ಹೇಳಿದ್ರು, ಅವ್ರ ಪಾಪ ಆ ಇನ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ ನಮ್ ಕೋರ್ಟ್ಗೆ ಬರೋದೇ ನಿಲ್ಲಿಸ್ಬಿಟ್ರು ಅವ್ರು. ಸರ್ ನಿಮ್ ಕೋರ್ಟ್ಗೆ ಬರಕ್ ಒಂಥರ ಆಗತ್ತೆ. ಏನ್ ಮಾಡ್ತೀರಿ, ಇಬ್ರು ವಕೀಲರ ಸಮ್ಮುಖದಲ್ಲಿ ಆಗಿದ್ದದು. ಅವ್ರ ಅಡ್ವೊಕೇಟ್ಸ್ ನಾನು ಹೇಳಿದ್ನ ನಿಮ್ಗೆ ಒಪ್ಕೊಳ್ಳಿ ಅಂತ ಕೇಳ್ತೇನೆ ನಾನು. ಏನ್ ಹೇಳಕ್ಕಾಗತ್ತೆ? ಅದಕ್ಕೆ ಒಳ್ಳೆದಾಟದ ಮೇಲೆ ಅಂಬಿಗಾ ಡ್ಯಾಶ್ ಅಂತ ಗಾದೆ ಬಂದಿರೋದು. ನಾನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲಪ್ಪ, ನೀವು ಅದನ್ನೇ ಕೇಳ್ಬೇಡಿ. ಅವೆಲ್ಲ ಕೇಳಕ್ಕಿಲ್ಲ. ಈಗ ಇಷ್ಟ ಮಾಡಿದ್ದೆ ಜಾಸ್ತಿ ನಾನು. ಆಲ್ ರೈಟ್, ಕಾಲ್ ನೆಕ್ಸ್ಟ್ ಕೇಸ್. ಅದ್ ಮಧ್ಯಾಹ್ನ ಅಂತಂದ್ರಲ್ಲಮ್ಮ ಅವರು, ಬಾಕಿ ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಅಂತ, ಬ್ಯಾಲೆನ್ಸ್ ಪೋರ್ಷನ್ ದುಡ್ಡು ಕೊಡ್ಬೇಕು. ಇಲ್ಲಿದೆ 38 ಅಲ್ಲಿ. ಯಾವ್ದಕ್ ಬರ್ತಾ ಇದೆ? ಅದೆಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಯ್ತಲ್ಲ, ಬಿಟ್ಟಾಕಿ. ಇದ್ಯಾಕೆ ಕ್ವೆಶ್ಚನ್ ಮಾಡ್ಬೇಕು ನೀವು? ಸರಿ, ಇವ್ರಿಗೆ MP ಶ್ರೀಕಾಂತ್ ಕ್ಲೈಂಟ್ಗೆ ಇವ್ರು ಇನ್ ಸ್ವಲ್ಪ ದುಡ್ಡು ಕೊಡ್ಬೇಕು, ಕೊಡ್ತಾರಷ್ಟೇ. ಅದೆಲ್ಲ ಮುಗ್ದೋಗಿದೆ. ಅದು ಮೇಜರ್ ಪೋರ್ಷನ್ ಆಫ್ ದಿ ಮನಿ ಇಸ್ ಗಿವನ್. ಅಲ್ಲೆಲ್ಲ ಒಂದ್ ಚರ್ಚ್ ಇತ್ತು, ಅದನ್ನ ತೆಗಿಬೇಕು ಅಂತ ಹೇಳಿದ್ರು, ಅದನ್ನ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಗ ಯಾರಿಗ್ ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಅಂತ ಆಯ್ತು, ಅದ್ರಲ್ಲಿ ಒಬ್ರು ಸತ್ತೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಇನ್ಯಾರಿಗೋ ದುಡ್ಡು ಕೊಡ್ಬೇಕಷ್ಟೇ. ಇದೆಲ್ಲ ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ 2:30. ಯಾರು ಇರ್ಲಿಲ್ವಲ್ಲ, ಯಾರು ಇಲ್ಲದೆ ಇದ್ರಲ್ಲಿ ನಾವೇನ್ ಈಗ ಮಾಡೋದು? It's my good thing that I have not dismissed. You have not complied the objections. No, nothing can be done. Yes, I have signed the order sheet, Mr. ಆಯ್ತು ಬಿಡಿ, ಅದನ್ನ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ದೀನಲ್ಲ ಇವಾಗ. ಏನಂತೆ? ಆಲ್ ರೈಟ್ 3110. ಹಾ, ಅವತ್ ಬನ್ನಿ. ಇನ್ನೂ ಆಲ್ ರೈಟ್, ಪಾಸ್ ಓವರ್. Process fees have been paid today. ಏನು ಯಾರು ಕೊಡ್ಬೇಕದು ನೋಟಿಸು? Issue notice to respond. You'll have to pay cost if you have not collected. Draft paper publication, though ready, was not collected by the appellant for issue of notice to unserved response by paper publication. Posta. Council submits that due to rush of work, she could not collect the draft from the office. Accordingly, issue fresh notice. Issue notice by fixing the date of hearing as 10/11/2023 and publication to be carried out on or before 31st of October 2023 on payment of cost of ₹500 to the Karnataka State High Court Legal Services Committee. Yes. ಬೆಳಗ್ಗೆಯಿಂದ ಚೆಕ್ ಕೊಡ್ತಾನೆ ಇದಾರಪ್ಪ, ಅದ್ ಯಾರು ಕೊಡ್ತಾರೋ ಕೊನೆಗೆ ಚಕ್ಕರ್ ಹಾಕ್ಬಿಡ್ತಾರ ಅಷ್ಟೇ. Patina. Case called twice, none present on behalf of the appellant. This court directed that suit amount, decretal amount with accrued interest to be deposited by the appellant. Order dated 3/10/2023 not complied. Accordingly, appeal stand dismissed for non-justice. ಎಲ್ಲಿ ಅವ್ರು ಯಾರೋ ಬರ್ತೀನಿ ಅಂದ್ರಲ್ಲ? He said he will come by physically and then argue the matter ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅಲ್ವಾ? All right, pass over. ಅವರೇ ಅವರು ಜಯಪ್ರಕಾಶ್ ಎಲ್ಲೋ ಹೋದ್ರಲ್ಲ, ಎಲ್ಲೋ ಹೋದ್ರು? Specific performance on injunction. ಅವ್ರಿಗೆ ಬೆಳಗ್ಗೆ ಟೈಮ್ ಕೇಳಿದ್ರು, ನಾ ಕೊಡಲ್ಲ ಅಂದೆ 2008 ಅಂತ, ಅದಕ್ಕೆ ಮಧ್ಯಾಹ್ನ ಬರ್ಲೇ ಇಲ್ಲ.
ಯಾರು ಮಾಡ್ತಾರೆ ಹಾಗೆ ಮಾಡಿ, ನಾನು ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ ಅದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ ಅವ್ರು
ಅದಕ್ಕೆ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬೇಡ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಮಾಡಿ ಇದೇನು ಅಂತ ಹೇಳ್ಬೋದು ಅದೆಲ್ಲ ಮೊನ್ನೆ ಒಂದು ರೆಕಾರ್ಡ್ ಆಗಿದ್ದೀನಿ ನಮ್ಮ ಕುರಿಗೂ ಆಫೀಸಲ್ಲಿ ಅವರು ಗಣಪತಿ ಓಡಾಡಲಿ
ತಪ್ಪೇನು ಅಂದೆ. ತಪ್ಪೇನಿಲ್ಲ ಬಿಡಿ. ನಾನ್ ಹೇಳ್ದೆ ಅದ್ರಲ್ಲಿ ಹೇಳಿರೋಂಥದ್ದು ಲಾಸ್ಟ್ ನಿಮಗ್ ಬಂದ್ರು ಕೂಡ ನೀವು ಅದನ್ನ ಗಣಪತಿಗೆ ಉಪಯೋಗಿಸ್ಕೋತೀರಾ ಅಂತ ಹೇಳಿದೀನಿ ಅಷ್ಟೇ. ಆಮೇಲೆ ಏನೋ ಪಾಪ ಅದ ಯಾಕೆ ಹಂಗ ಅನ್ಕೋತೀರಿ? ಸಿದ್ಧಿವಿನಾಯಕ ಎಷ್ಟ್ ದಿವಸ ಇಟ್ಟಿರ್ತಾರೋ ಅಷ್ಟ್ ದಿನ ಇರಿ, ಸಂತೋಷವಾಗಿರೋದು. ನೋಡಿ ಅದೊಂದೇ ಪಾಸ್ಪೋರ್ಟ್ ಇನ್ ಟೈಮ್. ಆ ಫ್ಲೈಟ್ ಯಾವತ್ತೂ ಡಿಲೇ ಇಲ್ಲ, ಅದೊಂದೇ ಯಾವತ್ತೂ ಡಿಲೇ ಇಲ್ಲ, ಆಲ್ವೇಸ್ ಆನ್ ಟೈಮ್, ರೈಟ್ ಆನ್ ಟೈಮ್. ಇದು ಸೆನ್ಸ್ ಆಫ್ ಡಿಟ್ಯಾಚ್ಮೆಂಟ್ ಯಾರು ಬೆಳೆಸ್ಕೊಂಡಿರ್ತಾರೋ ಅವ್ರಿಗೆ ಸಾವಿಗೆ ಭಯ ಇರೋದಿಲ್ಲ. ಯಾವತ್ತಿದ್ರು ಹೋಗ್ಬೇಕಪ್ಪ, ಇವತ್ತೇ ಹೋದ್ರೆ ಸಂತೋಷ, ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ದಿನ ಬಿಟ್ಟು ಹೋದ್ರು ಸಂತೋಷ, ಇರೋಷ್ಟು ದಿನ ಚೆನ್ನಾಗಿದ್ರೆ ಆಯ್ತು ಅಂದ್ರೆ ಆಯ್ತು. ಅವಾಗ ಸೆನ್ಸ್ ಆಫ್ ಡಿಟ್ಯಾಚ್ಮೆಂಟ್ ಬೆಳೆದ್ಬಿಡುತ್ತೆ. ಅಯ್ಯೋ ಇನ್ನೂ ಅದ್ ಮಾಡ್ಬೇಕು, ಅಯ್ಯೋ ಇನ್ನೂ ಇದ್ ಮಾಡ್ಬೇಕು, ಅಯ್ಯೋ ಇನ್ನೂ ಅಷ್ಟು ದಿನ ಇರ್ಬೇಕು ಅಂದ್ರೆ ಅದಕ್ಕೆ ಲೆಕ್ಕಜಮೆ ಇರೋದಿಲ್ಲ, ಲೆಕ್ಕಜಮೆನೇ ಇರೋದಿಲ್ಲ. 40 ವರ್ಷ ಆಯುರ್ದಾನ ಮಾಡಿಸ್ತಾರೆ ವಿಜಯದಾಸರು ಗೋಪಾಲ್ ದಾಸರ ಕೈನಲ್ಲಿ. ಜಗನ್ನಾಥ ದಾಸರಿಗೆ 40 ವರ್ಷ ಆಯುಷ್ಯ ಕೊಡು ಅಂತಾರೆ. 10 ಪೈಸಾ ತೆಗೆದುಕೊಡೋದಕ್ಕೆ ಹಿಂದೆ ಮುಂದೆ ನೋಡುವಂತ ಸಂದರ್ಭದಲ್ಲಿ 40 ವರ್ಷ ಆಯುಷ್ಯ ಕೊಡು ಅಂದ್ರೆ ನೀವ್ ಹೇಳಿದ್ರೆ ನಾನು ಕೊಟ್ಬಿಡ್ತೀನಿ ಅಂತಾರೆ. ಗೋಪಾಲ್ ದಾಸರು ಮಹಾಮಹಿಮರು, ಗಣಪತಿ ಅಂಶಸ್ಥರು ಅವ್ರು ಹೇಳ್ತಾರೆ, ಒಂದು ಒಳ್ಳೆ ಕಾಸ್ಗೆ ನೀವ್ ಹೇಳಿರ್ತೀರಿ, ಹಾಗಾಗಿ ನಾನು 40 ವರ್ಷ ಏನು ನೀವ್ ಹೇಳಿದ್ರೆ ನಂದಿರೋ ಅಷ್ಟು ಬಾಕಿ ಆಯುಷ್ಯ ಪೂರ್ತಿ ಕೊಟ್ಬಿಡ್ತೀನಿ ಅಂತ. ಇಲ್ಲ, ನಿನ್ನ ಹತ್ರನು ಸ್ವಲ್ಪ ಕೆಲಸ ಆಗ್ಬೇಕಾಗಿದೆ, ನೀನ್ ಅಷ್ಟು ದಿನ ಇರು, ಆಮೇಲೆ 40 ವರ್ಷ ಕೊಡು ಅವ್ರಿಗೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಮರುಮಾತಾಡದಲ್ಲೇ ಬರ್ತ್ ಕೊಟ್ಬಿಡ್ತಾರೆ ಅವರು. ಆವಾಗ ಕೂತ್ಕೊಂಡು ಜಗನ್ನಾಥ ದಾಸರು ಹರಿಕಥಾಮೃತ ಸಾರ ಅಂತ ಗ್ರಂಥ ಬರೆದಿದ್ರು. ಒಂದು ದಿವಸ ವೇಸ್ಟ್ ಮಾಡಬಾರ್ದು ನೀನು, ಈ 40 ವರ್ಷ ಪೂರ್ತಿ ನಿಂಗೆ ಸಿಕ್ಕಿದ್ದು ಬೋನಸ್ಸು, ಇದ್ರಲ್ಲಿ 1 ನಿಮಿಷ ನಿನ್ನ ಹಾಳು ಮಾಡೋ ಹಾಗಿಲ್ಲ, ಪ್ರತಿ ದಿವಸ ಕೂತ್ಕೊಂಡು ಇದನ್ನ ಮಾಡ್ಬೇಕು. ಅದನ್ನ ಅಚ್ಚುಕಟ್ಟಾಗಿ ಅವರು ಕನ್ನಡದಲ್ಲಿ ಸಿಕ್ಲಿ ಎಲ್ಲಾರ್ಗು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡಿದಂತ ಗ್ರಂಥ. ಎಷ್ಟೋ ಜನ ಡಾಕ್ಟರೇಟ್ಗಳು ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದ್ರ ಮೇಲೆ ಬರೆದು. ಇನ್ನೂ ಅರ್ಥ ಆಗದಿರೋದು ಬೇಕಾದಷ್ಟಿದೆ ಅದ್ರಲ್ಲಿ, ಡಾಕ್ಟರೇಟ್ ತಗೊಂಡ್ರು. ಅಂಥ ರಾಜ್ಯ ನಮ್ದು, ಅಂತ ಪ್ರದೇಶ ನಮ್ದು. ಈಗೇನೋ ರಾಜ್ಯ ಅಂತಿದೆ, ಹಾಗೆಲ್ಲ ಆಗಿದ್ದಂತ ಕರ್ನಾಟಕ ದೇಶ ಅಂತ. ಅಂಥದ್ರೊಳಗಡೆಗೆ ಸೆನ್ಸ್ ಆಫ್ ಡಿಟ್ಯಾಚ್ಮೆಂಟ್ ಇಲ್ಲದೆ ಇದ್ದಿದ್ರೆ ಅವ್ರು 40 ವರ್ಷ ಕೊಡಂದ್ರೆ ಕೊಟ್ಬಿಡ್ತಿದ್ರ? ಅಷ್ಟೆಲ್ಲ ಸುಲಭ ಆಗೋದಿಲ್ಲ. ಅದರಿಂದ ನೀವು ಸದ್ವಿನಿಯೋಗ ಮಾಡ್ತಿದ್ರಿ, ಆ ಸದ್ವಿನಿಯೋಗ ಮಾಡ್ತೀರಾ ಅಂತ ನನಗೆ ಗೊತ್ತಿದೆ, ಅದನ್ನ ಹೇಳಿದೀನಿ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಅದ್ರಲ್ಲಿ ಏನ್ ತಪ್ಪೇನಿಲ್ಲ. Once the cost is imposed and it is paid to you, it is your money. You can use it for whatever be the purposes. Since the court knew what you are going to make use of, it only got endorsed, that's all. Nothing more, nothing less. ಅಲ್ಲ ಏನ್ ತಪ್ಪಿಲ್ಲ ಬಿಡಿ. ಏನ್ ನಾವೇನಾದ್ರು ಪಾಪ ಕರ್ಮಕ್ಕೆ ನೀವು ಉಪಯೋಗ ಮಾಡ್ತಿದ್ದೀರಾ ಅಂತ ನಾನು ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ ಅದರಿಂದ ಸರಿ, ಒಳ್ಳೇದು. ಇಲ್ಲ ನನ್ಗೇನಿಲ್ಲ. ಎಲ್ಲ ಇವತ್ತು ರೋಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗದೆ ಇದ್ರೆ ಸ್ವಲ್ಪ ಟೆನ್ಷನ್ ಆಗೋದು. ರೋಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗಿರೋದ್ರಿಂದ 2015 ತನಕ ನಂದೇನೆ, 15 ಅಪೀಲ್ ವರ್ಗು ನಂದೇನೆ, 16ರಿಂದ ಕೃಷ್ಣಕುಮಾರ್ ಸಾಹೇಬ್ರ ಹತ್ರ. ಸೊ ಹಂಗಾಗಿ 16 ಅವರಿದ್ರೆ 2015 ವರೆಗೂ ಎಲ್ಲ ಫುಲ್ಲು. ಯಾಕಾಗಲ್ಲ? ಈಗಿದ್ದು ಹಂಗೇನೇನೆ. ಅಲ್ಲ ಈಗಿರೋದು ಅಷ್ಟೇ, ಈಗ 16 ಹೊರಗಿದೆ. ಆಗ ಅದನ್ನ ಒಂದ್ ಕಡಿಮೆ ಮಾಡಿದ್ರು ಅಷ್ಟೇ. 2015 ಮಾಡಿದ್ರು ಅಷ್ಟೇ. ಈಗ ಇದು ರೀಚ್ ಆಗ್ಲಿಲ್ವಾ? 2008 ರೀಚ್ ಆಗುತ್ತೆ. ಈ ರೋಸ್ಟರ್ ಮುಗಿಯೋ ತನಕ ಡಿಸೆಂಬರ್ 21 ತನಕ. ಡೇಟ್ ಏನ್ ಕೊಟ್ಟಿಲ್ಲ, ನಿಮ್ಗೆ ಕೇಳಿದ್ ಕೊಟ್ಬಿಡೋದಷ್ಟೇ. ಆಲ್ ರೈಟ್. Case called in the afternoon session, counsel for appellant absent, counsel for contesting respondent present. First, release this matter on 9/11. Nilvalri avaru, counsel for appellant, case called twice, counsel for appellant absent. Release this matter on 9/11. ಶ್ರೀನಿವಾಸ್ ಇದೆ ಅಲ್ವಾ? ಮನಿ ಡಿಗ್ರಿ ಅರ್ಧ ಕೇಳಿದ್ವಲ್ಲ. You have heard it in part. ಈಗ ಬೇರೆ ಇದೆ, 992 ಕೊಡ್ತಾ ಇದ್ದೀರಿ. ಇದೇನು ಕೇಳಿರ್ಲಿಲ್ಲ ನಾವು. Case called twice, none present on behalf of the appellant. Release this matter on 9/11. ಅದು ಅಡ್ಮಿಷನ್ ಡೀಸೆಲ್ ಅದು ತಗೊಳ್ಳೇದು ರಾಜಗೋಪಾಲ ಮತ್ತೆ ಇವ್ರದ್ದು ಯಾವ್ದಾದ್ರು ಒಂದು ಇರೋ ಮ್ಯಾಟರ್ ಅಂತ ತರ್ಸ್ಕೊಂಡ್ಬಿಡಿ. ಟ್ರೇಡ್ಮಾರ್ಕ್ ಇರ್ತಲ್ಲ ಅದನ್ನ ಬೇಕಾದ್ರೆ ತರ್ಸ್ಕೊಂಡ್ಬಿಡಿ. ಇಲ್ಲೇ ಕೂತ್ಕೊಂಡು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ, ಬರೋದಾಗತ್ತೆ. ತೀರಾ 3 ಗಂಟೆ 4 ಗಂಟೆ ಅಂತ ಗೊತ್ತು. ಎಸ್ ಪ್ಲೀಸ್, ಒಂದೇ ಆಡ ತರ್ಸ್ಕೊಳ್ಳಿ. ಹೇಳಿ, ಅದೇನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ. item number 1 and 2 you said that it has been sold. Correct. No, who sold the property? It is you say. No, he says after the death of father you sold. One of the sons sold. Date ಹೇಳಿ ಅಂತ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು ತಮ್ಗೆ ಬೆಳಗ್ಗೆ. ಅಲ್ಲ ಇವ್ರೆ, ಐಟಮ್ ನಂಬರ್ 1 ವರ್ಟೆಸ್ಟ್ ಪ್ರಾಪರ್ಟಿ ಹೇಳಿ. ಎಷ್ಟಿತ್ತು, ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟಿತ್ತು? 4 acres 20 ಗುಂಟಾಸ್. ಆಫ್ ಯಾವ ವಿಲೇಜು? Item number 2 30 ಗುಂಟಾಸ್. ಆಲ್ ರೈಟ್. ಇವಾಗ 4 acres 20 ಗುಂಟಾಸ್ ಎಂಟೈರ್ ಪ್ರಾಪರ್ಟಿ ಡಿನೇಮ್ ಮಾಡಿದ್ದಾರೆ. ಐಟಮ್ ನಂಬರ್, ಒಂದ್ ನಿಮಿಷ ಕೇಳಿ, 1 by 1. ಐಟಮ್ ನಂಬರ್ 1 and 2 ಎರಡು ಡಿನೇಮ್ ಮಾಡಿದ್ದಾರೆ, ಕೊಟ್ಟಿಲ್ಲ ಶೇರ್. Suit is dismissed in respect of item number 1 and 2. Now, property belong to whom? ಮುನಿ ವೆಂಕಟಪ್ಪ. ಆಯ್ತಾ? ಎಷ್ಟು ಜನ ಮಕ್ಕಳು? ಮೊದಲನೇ ಹೆಂಡತಿ ಹೆಸರೇನು? ಎರಡನೇ ಹೆಂಡತಿ ಹೆಸರು? ಅಕ್ಕಮ್ಮ. ಯಾವಾಗ ಮದ್ವೆ ಅಕ್ಕಮ್ಮಂದು? ಇಲ್ದೆ ಹೋದ್ರೆ ಎರಡನೇ ಹೆಂಡತಿ ಮಕ್ಕಳಿಗೆ ಶೇರ್ ಬರಲ್ಲ. ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದೀನಿ, ಅದನ್ನೇ ಯಾವಾಗ ಅಂತ. ದಟ್ ಇಸ್ ದಿ ಇಂಪಾರ್ಟೆಂಟ್ ಥಿಂಗ್ ಒನ್ ಹ್ಯಾಸ್ ಟು ಸೇ. ಆಲ್ ರೈಟ್. ಪಾಪಮ್ಮಂಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳು? ಯಾರ್ಯಾರು? All right. Akkamange. ಆಯ್ತು. ಮುನಿವೆಂಕಟಪ್ಪ ಸತ್ತಿದ್ ಯಾವಾಗ? 1992. ನಿಮ್ ಸೇಲ್ ಡೇಟ್ ಯಾವಾಗ ಮಿಸ್ಟರ್ ಇವ್ರೆ? When was the party? ಯಾರ್ಯಾರ ಮಧ್ಯ ಆಯ್ತು? ಯಾರ ಸನ್ಸ್ ಅಂದ್ರೆ?
During the lifetime of the party for the fourth of all the certified. Just the mutation entry during his lifetime. It says that fell to the property that fell to the share of Louis Farm in 1986. It fell in 2008. Therefore, the private after the death of his father, the interest has been changed.
When was the mutation? Admit, call for trial court records. Paper books in 12 weeks. Post for hearing. Even otherwise, partition ಹೋಗುತ್ತೆ. Second wife, ಇಬ್ರು sons ಇದ್ದಾರೆ, 3 ಜನ daughters ಇದ್ದಾರೆ. ಸ್ವಲ್ಪ ಬೇಡಪ್ಪ, ಇವಾಗ ಸೆಲ್ಫ್ ಅಕ್ವೈರ್ಡ್ ಪ್ರಾಪರ್ಟಿ ತಾನೆ. ಅಲ್ಲಿಗೆ ಮುಗಿದೋಯ್ತು ಅಷ್ಟೇನೆ. ಎಲ್ಲಾರು ಸೆಕ್ಷನ್ ಅವ್ನ್ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೋತೀನಿ ಅಂತಂದ ಅವ್ನ ಜೀವಿತ ಕಾಲದಲ್ಲಿ ಬರೇ ಮಕ್ಕಳ ಜೊತೆ ಮಾಡ್ಕೊಳಕ್ ಆಗಲ್ಲ. ಮೊದಲನೇ ಹೆಂಡತಿ ಮಕ್ಕಳ ಜೊತೆಗೆ. ಪ್ರೀ ಸಪೋಸಸ್ ದಟ್ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ. ಒಂದ್ ನಿಮಿಷ, ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಆಯ್ತು. ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಆದ್ರೆ 4 ಜನ ಗಂಡ್ಮಕ್ಳು ಪ್ಲಸ್ ಮುನಿವೆಂಕಟಪ್ಪ, ಅದು 1/5 ಶೇರ್ ಆಯ್ತು. 1/5 ಶೇರ್ ನ ಫರ್ದರ್ ತಿರ್ಗಾ 10 ಮೆಂಬರ್ಸ್ ಜೊತೆಗೆ ಹೋಗ್ಬೇಕು, 11 ಮೆಂಬರ್ಸ್ ಜೊತೆಗೆ ಹೋಗ್ಬೇಕು. ಅದು ಯಾವ್ದು ಎಲ್ಲ ಪೂರ್ತಿ ವಜಾ ಮಾಡಿಟ್ಬಿಟ್ರೆ ಅವನು 1 and 2 2 ಮಾಡಿಟ್ಬಿಟ್ಟಿದ್ದಾನೆ ಪೂರ್ತಿ. No, the problem is ಅದನ್ನ ಮಾಡ್ಕೊಳಕ್ಕೆ ಬರ್ತಿರ್ಲಿಲ್ಲ. On what ground that he partitioned the property? It's a self-acquired ಆದ್ರೆ. Where was the necessity to have any partition?
The unregistered partition deed will say that it was partition of sale that is also expected.
Irli ಮಾಡಿರ್ಲಿ. The point is, if it is a self-acquired property, there is no question of any partition. Self-acquired property ಆದ್ರೆ ಬೇಕಾಗಿರಲಿಲ್ಲ. As against defendants have specifically contended that there was a oral partition. Same was reduced into writing on 3489. Exhibit D 204, 206, 209 are the documents dated 3489. While marking these documents, direct counsel for the plaintiff raised a subjection on the ground that those documents are unregistered documents and no proper stamp duties are paid. Or this court by detailed order has come to the conclusion these documents can be received in evidence as no partition was effected. So these documents and earlier oral partition has been reduced into writing. Plaintiffs have not challenged the order passed by this court. Partition may be effected orally, but if subsequently reduced into form of a document, purpose to itself into effect decision embodies all the so and so. However, recitals of so and so read as under. ಎಲ್ಲರಿಗಳಿಗೂ ಲಗ್ನ ವಗೈರಾದಿಗಳನ್ನು ಮಾಡಿ ನಂತರ ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಒಂದೇ ಕುಟುಂಬದಲ್ಲಿ ಇರಲು ಒಬ್ಬರಿಗೊಬ್ಬರು ಸರಿ ಇಲ್ಲದೆ ಬೇರೆ ಬೇರೆ ಹೋಗಬೇಕೆಂದು ಇಚ್ಛೆಪಟ್ಟಿನಿಂದ ಹೋಗಬೇಕಾದಲ್ಲಿ ಸ್ಥಿರಾಸ್ತಿಗಳನ್ನು ಹಂಚ ಮಾಡಿಕೊಂಡು ಸ್ಥಿರಾಸ್ತಿಗಳನ್ನು ಸಹ ಹಂಚಿಕೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾಗಿ ಯಾವ ಕಾಗದ ಪತ್ರಗಳು ಬರೆಸಿಕೊಟ್ಟಿರಲ್ಲ. ಇದೇ ರೀತಿ ಮುಂದುವರೆದಲ್ಲಿ ನಿಮ್ಮ ಭಾಗ ಸ್ವತ್ತುಗಳ ಮೇಲೆ ಸರ್ಕಾರದಿಂದ ಸಹಕಾರ ಸಂಘದಿಂದಾಗಲಿ ಸಾಲ ಸೌಲಭ್ಯಗಳು ದೊರೆಯೇ ಮುಂದುವರೆಯಲು ಸಾಧ್ಯವಾದ ಕಾರಣ ಈ ದಿನ ಕೆಳಕಂಡ ಪಂಚಾಯತ್ ದರ ಮುಕ್ತ ವ್ಯವಸ್ಥಾಪತ್ರವನ್ನು ಬರೆಸಿಕೊಂಡಿರುತ್ತೇನೆ. It is not actually the partition, it is a settlement. If there is a settlement, then you could not have, only you four could not have been. Nan right ಇದೆ, ನಾನು ಯಾಕೆ ಬಿಡ್ಲಿ? ನನ್ ರೈಟ್ ಇದೆ. ಆ ಈವನ್ ಅದ್ರ ಕೋಪಾರ್ಷನ್ ಅಂತ ತಗೊಂಡ್ರೆ ಆ ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 1 ಸೇರಿಸ್ಬೇಕು ವಿನೀತಾ ಶರ್ಮಾ ಪ್ರಕಾರ, ಅವಳಿಗೂ ಶೇರ್ ಕೊಡ್ಬೇಕು. ಮತ್ತೆ ಅಷ್ಟಕ್ಕಾರ್ ಡಿಕ್ರಿ ಮಾಡಿದ್ರೆ ಮುಗ್ದೋಯ್ತಲ್ಲ. ಅದ್ರಲ್ಲೆಲ್ಲ ಪ್ರಶ್ನೆ ಅಲ್ಲ. 3 and 4 ಅಂತ ಯಾಕೆ 1 and 2 ನಲ್ಲೂ ಕೊಡ್ಬೇಕು. ಅವ್ಳಿಗೆ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಇದೆ ರೈಟ್. She being the daughter of Papamma, she is entitled for the share in all properties as if she is a co-personal, assuming that it's a joint family. Self-acquired adre settlement cannot be only among the 4 children. It could self-acquired ಆಯ್ತು ಅಂತಂದ್ರೆ it cannot be only among the 4 children. ಪಾಪಮ್ಮಂಗೂ ಸೆಟ್ಲ್ ಆಗ್ಬೇಕು, ಪಾಪಮ್ಮನ ಮಗಳಿಗೂ ಸೆಟ್ಲ್ ಆಗ್ಬೇಕು, ಅಕ್ಕಮ್ಮಂಗೂ ಸೆಟ್ಲ್ ಆಗ್ಬೇಕು. ಅಕ್ಕಮ್ಮನ್ ಬಿಟ್ಬಿಡ್ತೀವಿ ಅಂತ ಇಟ್ಕೊಂಡ್ರು ಕೂಡ ಅಕ್ಕಮ್ಮನ್ 5 ಮಕ್ಳಿಗೆ ಸೆಟ್ಲ್ ಆಗ್ಬೇಕು. ಅವ್ರಿಗೇನಾರು ಔಟ್ಸೈಡ್ ದಿ ಕೋರ್ಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಮ್ಯಾಟ್ರೆ ಮುಗ್ದೋಗುತ್ತೆ. ಇನ್ಯಾವುದು ಎಲ್ಲಾರು ಅಂದ್ರೆ ಯಾರು? ಸೆಕೆಂಡ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್. ಅದಕ್ಕೆ ಅಕ್ಕಮ್ಮನ ಮಗಳ ಮದ್ವೆ ಯಾವಾಗ ಅಂತ ಕೇಳಿದ್ ನಾನು. ನೋಡ್ಲಿ ಅವ್ರು ಏನೋ ಮಾಡ್ಲಿ, ಅದೇನು ಈ ಜನ್ಮಕ್ಕೆ ತೀರ್ಮಾನ ಆಗಲ್ಲ. ಎಲ್ಲಿ ತೀರ್ಮಾನ ಆಗತ್ತೆ? ನೀವು ಸರಿ, ಅಪೀಲ್ ಈಗ ಅಡ್ಮಿಟ್ ಆಗ್ತಾ ಇದೆ, ಯಾವ ಕಾಲಕ್ಕೆ ತೀರ್ಮಾನ ಆಗುತ್ತೆ? ಓ ಫಾರ್ ಎವರ್. ಬರುತ್ತೆ, ಬಟ್ ಎಲ್ಲಿ ಎಷ್ಟು? ನಾನೇ ಒಬ್ನೇ ಎಷ್ಟು ಮಾಡಕ್ಕಾಗತ್ತೆ ಅಭಿನವ್? ಮಾಡಬಾರ್ದು ಅಂತೇನಿಲ್ಲ, ಬೇಕಾದಷ್ಟು ಮಾಡ್ಬಿಡಿ. ಹೋದ್ ಸತಿನೂ ಹಂಗೆ ಆಯ್ತು. Taking the clue from the previous time, I thought that this time also it will continue. Only change from the previous year roster to this year roster is second time ಅಲ್ಲಿ ಬರೀ RFA ಮಾತ್ರ ಮಾಡಿದ್ರು. ಈ ಸರಿ RFA and IPR ಎರಡು ಕಂಟಿನ್ಯೂ ಮಾಡಿ. Maybe the IPR lawyers are also happy. ಈಗ ಹೋದ್ ಸತಿ ಏನಾಯ್ತು, IPR ನ ತೆಗೆದ್ಬಿಟ್ಟು ಬರೇ RFA ಮಾತ್ರ ಕೊಟ್ಟಿದ್ವಿ ಸೆಕೆಂಡ್ ಟೈಮ್ ರೋಸ್ಟರ್ಗೆ. ಈ ಸರಿ 1 ವರ್ಷ RFA ಕಟ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. 2016 ಇದ್ದಿದ್ದು 2015 ವರೆಗೂ ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು. ಇವನ್ ದೆನ್ ನಾನು ಬೆಳಗ್ಗೆ ಎಲ್ಲ ಚೆಕ್ ಮಾಡಿ ನೋಡಿದೆ, 40 ವರ್ಕಿಂಗ್ ಡೇಸ್ ಬರುತ್ತೆ, 41 ಡೇಸ್, 42 ವರ್ಕಿಂಗ್ ಡೇಸ್ ಬರುತ್ತೆ, ಸಬ್ಜೆಕ್ಟ್ ಟು ಮೀ ಅವೈಲಿಂಗ್ ಎನಿ ಲೀವ್ ಇಫ್ ಎನಿ. ಅಷ್ಟೇ. ಅದ್ ಬಿಟ್ಬಿಟ್ರೆ ಸಾಧಾರಣ ಏನಿಲ್ಲ, ನಾನು ರಾಜಾ ಆಗೋದೇ ಕಡಿಮೆ. ನಾನು ಅದರಿಂದ ಅದನ್ನ ಲೆಕ್ಕ ಹಾಕಿದ್ರೆ ಇರೋದನ್ನ ಅಷ್ಟಕ್ಕಾಗತ್ತೆ. ಅಷ್ಟಕ್ಕಾದ್ರೆ ಮುಂದೆ ನೋಡ್ಬೇಕಲ್ಲ, ಬರ್ಬೋದು ಅಂತ ಒಂದು ಅಂದಾಜು ಅನ್ನಿಸ್ತಾ ಇದೆ. ಎಕ್ಸೆಪ್ಟ್ ಫಾರ್ ದಿ ಕೇಸಸ್ ವೇರ್ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ಅವು ಇವು ಇರುವಂತದ್ದು. ನೋಡೋಣ ಎಷ್ಟೆಷ್ಟಾಗುತ್ತೋ ಅಷ್ಟಷ್ಟು ಮಾಡ್ತಾ ಹೋಗೋದು. ಸರ್ಕಾರದ ಬಂತ ಅಫಿಡವಿಟ್? affidavit filed on behalf of the Tahsildar, Bangalore South Taluk. Affidavit of Tahsildar South Taluk filed. First, copy furnished to the appellant and respondent. First, affidavit is taken on record. List this matter on 31st of October for further consideration. ಅಟೋತ್ತಿಗೆ ಇನ್ನೇನಾದ್ರು ಸಿಗುತ್ತಾ ನೋಡಕ್ಕೆ ಹೇಳಿ. ಆಯ್ತು. ನೋಡೋಣ ಅದೇನಿದೆ ಅವ್ರು ಕೊಡ್ಲಿ ಅದನ್ನ. ನೋಡೋಣ They are not a party before the court, mister. ಏನೋ ಇಷ್ಟು ಮಾಡಿದಾರೆ ಸಹಾಯಕಷ್ಟು. ನಾವು ಅವ್ರನ್ನ ಧರ್ಮಕ್ಕೆ ಕರೆದವ್ರನ್ನ ಇನ್ನೆಷ್ಟು ಮಾಡಿ ಗುಜ್ಜೋದು. ಅದ್ ನಿಮ್ ಜವಾಬ್ದಾರಿ. Or when they have come up with a specific stand, it is for you to meet. You file if you want to take any other stand, you file necessary application ಅಷ್ಟೇ. ಅಷ್ಟೇ ಅದ್ ಬಿಟ್ಟು ಇನ್ನೇನಿರುತ್ತೆ. ಅವ್ರು ಬಂದ್ರ ಶೇಷಗಿರಿ ಅವರು ಕೊಟ್ಟಿದಾರಾ? ಹೇಳಿ, ಒಂದ್ ಮೆಮೊ ಕೊಡಿ. ಕೇಸ್ ಕಾಲ್ಡ್ ಶ್ರೀ MP Srikanth files a memo, affidavit of Ammaji Begum, Abdul Samad, Sanaullah. Idile so and so 7B 7C tanka tagoli aita so and so, stating that they have received the entire money as per the compromise decree that has been passed earlier. First, next para. Affidavit is placed on record and therefore compliance of the order dated so and so is avatin original compromise order nodi, original first day hodru ಅಷ್ಟರದ್ದು 2022 ನಲ್ಲಿ compromise decree nodi dated 5/12/2023 is complied in toto. Sri MP Srikanth has acknowledged the receipt of checks mentioned in the affidavit by signing the order sheet. First, aita order sheet ಅಷ್ಟೇ close. ಅದು affidavit ಅಲ್ಲಿ ಬರ್ದಿದ್ದೀರಲ್ಲ ಅಷ್ಟೇ ಸಾಕು. ನಾನು ಅದಕ್ಕೆ ಬರ್ದೀನಿ ಟೋಟಲ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಂತ. ನೀವು ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ, ಅದು ನಿಮಗ್ ಬಿಟ್ಟಿದ್ದು. ಇನ್ಯಾರು ತಕರಾರು ಮಾಡ್ಕೋಬಾರ್ದಷ್ಟೇ. ಮುಗೀತಾ? ರಿಸರ್ವ್ ಮ್ಯಾಸ ಕೊಡಿ ಪ್ಲೀಸ್. ಒಂದು 3 really ಒಂದು film. Present appeal is directed against the judgment and decree passed in OS number 5 of 2000 on the file of Civil Judge Senior Division Arsikere. Dated 21/12/2005. First, parties are referred to plaintiff and defendants for the sake of their convenience as per their original ranking before the trial court. First, next para. A suit for partition came to be filed by the plaintiff against the defendants, claiming 1/6 share in respect of the following properties: hereinafter referred as, which are hereinafter referred as two properties. First, next para. Plaintiff laid their claim, stating that first defendant, being the son of Timmegoda, had 5 sons, namely plaintiffs and defendant number 3 and 4, who are plaintiffs and defendant number 3 and 4, and second defendant is the wife of first defendant. First, it is contended that parents of the first defendant died when the first defendant was very young, and therefore, comma, maternal uncle of the first defendant by name Ije Gowda had sold few properties of the family on 8/5/1945 and took the first defendant to Bageshpura village, and from out of the sale consideration, in the sale consideration of the properties which were sold in Arsikare, Arsikare village, Arsikare alla, of Bedagali village, purchased land in survey number 5/2 of Bageshpura village, Posta. On attaining majority, first defendant married the second defendant, and plaintiffs and defendant number 3 and 4 were born in the said marriage. Plaintiffs are working as drivers in KSRTC. First plaintiff is working as driver in the KSRTC, and other parties to the suits are managing the agricultural land. First, it is further contended that from the agriculture income, derived from the fertile land in Bageshpura, other items of the suit properties mentioned in Schedule A have been purchased. First, therefore, all the suit properties are joint family properties. First, it is further contended that in order to augment augment the income of the joint family, parties decided to purchase a tractor and trailer for effective agriculture operations, and in that regard, they approached the Kaveri Gramin Bank for obtaining the loan, and at that juncture, the bank wanted security. First, it is further contended that the joint family properties were given as security for purchase of the tractor and trailer. First plaintiff also contributed to the joint family from his salary earnings, and the efforts put by the other plaintiffs and defendant number 3 and 4 are all put to common hodgepodge, and the family was maintaining the expenses from the common hodgepodge. First, next para. When the matter stood thus, about 15 days earlier to the filing of the plaint, and the plaintiffs visited the agricultural lands for agriculture operations, all the defendants picked up the quarrel and obstructed the plaintiffs to cultivate the lands, and also directed that the plaintiff should vacate the ancestral house. First, it is further contended that the shares would not be given to plaintiffs as there is already a judgment in their favor from the court. First, thereafterwards, plaintiffs inquired with their advocate and found that defendant number 3 and 4 had filed a suit in OS number 361 of 1999 against defendants 1 and 2 on the file of Civil Judge Junior Division Arsikere, and on 27/11/1999 filed on and on 29/11/1999 the said suit ended in a compromise decree, and plaintiffs were not party to the said compromise decree, and therefore contended that the judgment passed in compromise decree passed in OS number so and so would not be binding on them, and sought for their share in the suit property. First, next para. Upon service of the suit summons, defendant number 3 and 4 alone appeared before the court and filed. Defendant number 3 and 4 appeared through their advocate and filed written statement, but defendant number 1 and 2, though appeared before the court, did not choose to file any written statement. First, next para. In the written statement of defendant number 3 and 4, it is contended that there was no land for the first defendant in Bedagali village as contended by Bedaguli village as contended in the plaint, and on account of death of the parents of first defendant in his young age, Ije Gowda acted as minor guardian and sold the land belonging to the first defendant through a registered sale deed to Honne Gowda, and from the money derived from the sale consideration derived from the said property, property in Bageshpura village has been purchased is denied. First, defendant number 3 and 4 denied that plaintiffs are also, that plaintiff number 2 and 3 are also worked in the agricultural land belonging to the first defendant in Bageshpura, and they are the members of the joint family. First, plaintiff further denied, defendant number 3 and 4 further denied that there was no contribution made by the plaintiffs and nothing was contributed by the plaintiffs so as to have a common hodgepodge, and no property was purchased from the joint family income, and sought for dismissal of the suit. Based on the rival contention of the parties, the trial court raised following issues and additional issues. First, next para. In order to prove the case of the plaintiffs, plaintiffs got examined. Five witnesses, SPW 1 to 5, and relied on 34 documents which were exhibited and marked as exhibit P1 to P34, comprising of next para. As against the evidence placed by the plaintiff, on behalf of the defendants, 7 witnesses were examined as DW 1 to 7, and they relied on 13 documents which were exhibited and marked as exhibit D1 to D13, comprising of so and so. Next para. Learned trial judge, after hearing the parties in detail, on conclusion, learned trial judge after conclusion, after recording the evidence of the parties, heard the parties in detail and decreed the suit of the plaintiff in part by granting in respect of item number 1 of the suit property, granting 1/6 share in the 1/6 share in the so and so in respect of item number 1 of the suit property alone. Further, it was decreed that the compromise decree obtained in OS number 361/1999 dated 29/11/1999 would not bind the plaintiffs in claiming the share, their share of 1/6 each in the item number 1 of the suit property. Being agreed by the same, being agreed by the decreeing of the suit in part by the defendant number 3 and 4 have challenged, have preferred this appeal on the following grounds. Sri so and so appearing for ಇಬ್ಬರಿದ್ದಾರೆ ನೋಡ್ಕೊಳ್ಳಿ. ಒಬ್ರು ಅವರು ಹಿರಿಯಣ್ಣ ಅಂತ, ಇನ್ನೊಬ್ರು ರಾಮಣ್ಣ ಅಂತ, ಅವರಿಬ್ಬರನ್ನ ತೋರಿಸ್ಕೊಂಡು ಇಬ್ರು ಅಪಲೆಂಟ್ಗೆ ಬೇರೆ ಬೇರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. Reiterating the grounds set in the appeal memorandum, Sri Hiriyanna and Sri Raman, MS Sri Raman and other, vehemently representing appellant number 1 and 2, vehemently contended that the trial court grossly erred in decreeing the suit in part in granting 1/6 share each to the plaintiffs in respect of item number 1 of the suit property, and also holding that the compromise decree so and so passed in so and so would not bind the plaintiff in so far as the item number 1 of the property. They further contended that the trial court has not taken into consideration that it is the self-acquired property of the Hanumantegowda and the first defendant, self-acquired property of the Hanumantegowda, and this and defendant number 3 and 4 got their share in respect of the suit property. Suit property as they have looked after the welfare of defendants 1 and 2 during their lifetime. Posta. And therefore, comma, they got their share in the compromise decree. Posta. They also contended that plaintiffs have harassed the defendant 1 and 2, including filing a criminal case, and therefore, comma, plaintiffs number 1 and 2 agreed to grant share only to the defendant number 3 and 4, excluding the share of the excluding the plaintiff. Posta. Next para. Further, the counsels for appellants, comma, contended that there is no iota of evidence placed on behalf of the plaintiff to show that there was a property in Bedaguli belonging to the first defendant, which has been sold by his maternal uncle Ichegowda as minor guardian of the first defendant, and sale proceeds thereof has been utilized for the purpose of purchasing the property of Bagesh Pura, which is the item number 1 of the suit property, and therefore, comma, trial court granting the decree in favor of the plaintiffs in by granting 1/6 share each in respect of the item number 1 of the suit property has resulted in miscarriage of justice and sought for allowing the appeal. Next para. Per contra, that counsel representing the contesting respondents, she so and so vehemently contended that the fact of first defendant possessing the property at Bedaguli village, and the same being sold to Honnegowda by Ijjegowda, acting as a minor guardian of first defendant, is proved by placing necessary evidence on record, and the same has been rightly appreciated by the learned trial judge while passing the impugn judgment and declaring the suit of the plaintiff in part. Posta. Next para. Also contended that when once the property at Bedaguli was sold and first defendant was brought to Bageshpura village and reared by the maternal uncle of the first defendant, namely Ijjegowda, the sale process thereof has been utilized for the purchase of the item number 1 of the suit property, as admittedly the first defendant had no avocation as on the date of, had no independent income as on the date of the purchase of the item number 1 of the suit property at Bageshpura, and material evidence on record would sufficiently establish that it is the sale process of the property which has been sold in Bedaguli village is utilized for the purchase of the first item of the suit property, and accordingly decreeing of the suit by granting 1/6 share in item number 1 of the suit property by the trial court in the impugn judgment to the plaintiff is just and proper and sought for dismissal of the appeal. First, next para. It is pertinent to note that the plaintiffs have not preferred any appeal or cross objection in respect of denial of in respect of dismissal of their suit in respect of the other items of the suit property and other reliefs claimed in the suit. First, next para. In view of the rival contents of the parties, this court peruses the matter law on record meticulously. On such perusal of the matter law on record, following points would arise for consideration. Whether defendant number 3 and 4 bracketal appellants have made out a case that item number 1 of the suit property, suit schedule property is the self-acquisition of first defendant, and thereby the plaintiffs had no right whatsoever to claim the right in respect of item number 1 of the suit property. Yardo. Whether the impugn judgment is suffering from legal infirmity and perversity and thus calls for interference. What are? Next para. ಅದಕ್ಕೆ ಇಟ್ಕೊಂಡಿರ್ತೀರಾ ಮುಂದೆ ನೋಡ ಇನ್ನೊಂದು ಇದೆಯಾ ಬಂದು ಒಂದೇ ತಂದಿರ ಇದ್ರೆ ಕೊಡ್ತೀನಿ ಅದನ್ನ ಬರ ಇದನ್ನ ಹೇಳಿಟ್ಟಿದ್ರೆ ಆಮೇಲೆ ಅದನ್ನ ಹೇಳ್ಕೋಬಹುದು ಅಂದ್ರೆ ನೀವು ರಜಲ್ಲೆಲ್ಲ ಕೂತ್ಕೊಂಡು ಅದನ್ನ ಮಾಡಿಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ ರೀಡಿಂಗ್ಸ್ ನ ಮಿಕ್ಕಿದೆಲ್ಲ ನಾವು ಯಾವ ಅದ್ಯಾವುದೋ ಒಂದು ಟ್ರೇಡ್ ಮಾರ್ಕ್ ಒಂದು MFA ಇತ್ತು ನೋಡು ಬಿಯಾನೋ ಎಂತದೋ ಬಿಜ್ಞಾನೋ ಯಾವನೋ ಡೆಲ್ಲಿ ಅವನೊಬ್ಬ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ನಲ್ಲ ಎಲ್ಲ ನಿಮಗೆ ದಪ್ಪ ತುಂಬೋದು ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ಮಾಡಿ ಓದಕ್ಕಾಗ್ಬಾರ್ದು This miscellaneous first appeal is filed by the plaintiff challenging the validity of the order passed in OS number 6500 of 2020 dated 20th January 2021 by the Additional City Civil Judge Bangalore within bracket CCH-10 whereby IA 123 filed by the plaintiff under Order 39 Rule 1 and 2 Federal Section 151 CPC came to be dismissed. First, parties are referred to as plaintiff and defendants for the sake of convenience as per their original ranking before the trial court. First, next para. Ali plaint copy ja. Plaintiff filed a suit invoice number 6500. ಆಯ್ತಾ ಸಾಕ್ಬಿಟ್ಟಿದೆ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಕೊತೀನಿ ಸಿಗುತ್ತಾ ಕೊಡಿ ಈ ಕಡೆ 2020 with the following prayer. First, next para. Plaintiff laid the claim plaintiff laid the claim in respect of the suit relief by contending that plaintiff is a registered company providing vast number of services pertaining to the product engineering and digital transformation to enterprises across the world involved in industries such as semiconductor, automotive, industrials, consumer electronics, enterprise devices, satellite communications, transport industries, etc. First, plaintiff being a public limited company, its shares are listed in the stock exchanges of the country and is represented by authorized signatory Shri Deepak Mahapatra. First, it is further contended that defendant number 1 is also a company incorporated under the provisions of the Companies Act 1956 and having a registered office in Bangalore. First, second defendant, only first defendant. Second defendant is a private limited company registered under the incorporated under the provisions of Companies Act and has registered office in Bangalore. First, plaintiff contended that plaintiff was originally incorporated in India in the name of ASIC Technologies Limited in the year 1989. First, in the year 2000, plaintiff changed its name to SASKEN Communication Technologies Limited, SASKEN anta. SASKEN Communication Technologies Private Limited, and has been using the word inverted comma capitals only SASKEN in its name and for the products and services ever since the year 2000. First, plaintiff having involved in several technological and allied services, including the hardware designing, software development, etc., for a period of 3 decades, has earned a goodwill and has got a wide range of customer base, including hundreds of customers who are Fortune 500 companies in the world, and plaintiff is a global leader in digital transformation services. First, plaintiff is having operations spread over 3 continents with their offices at Japan, United States of America, Germany, Finland, United Kingdom, China, Mexico, and India. First, next para. It is further contended that plaintiff's name Sasken is a distinctive mark that is well known in the field of technological and allied services for several years, and therefore they have built a goodwill among its customers. First, the trademarks of the word SASKEN denoted comma and its various variants registered by the plaintiff in India are as under. ನೋಡ್ಕೊಂಡು ಇದನ್ನ ಹಾಕೊಳ್ಳಿ. ಸೇಮ್ ಅದೇ ತರ ನೀವು ಮಾಡ್ಕೊಂಡು ನೀವೇ ತಕೊಂಡು. ಫಸ್ಟ್, plaintiff obtained registration certificate in respect of its trademarks in India, and it also registered its trademarks containing the word Sasken in various countries as detailed as under and detailed as under. ನೋಡಿ ಇಲ್ಲಿ ಹಾಕ್ಬಿಡಿ ಇದನ್ನು 1 to 16 ಆಯ್ತಾ. Plaintiff has its 30 plus years, 3 decades operations as in its 3 decades operations, steadily grown among the top companies in India and abroad, providing number of technological services to its clients, and annual turnover of the plaintiff for the financial year 2019-20 was INR 527.9711 ಅದನ್ನು ನೋಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. So and so ಆಯ್ತಾ 527 crores 97 lakhs and 11,000. First, it is further contended that in July 2020, plaintiff found out that through the newspaper article that technological services being offered in the market by name SalesCan, SALESKEN, inverted comma, all capitals within inverted comma, which bears the marked visual, structural, as well as phonetic similarity to the plaintiff's trademark SASCAN. First, upon further inquiry, comma, plaintiff was shocked to note that first defendant obtained registration for the word SalesCan with trademark registry under class 42, class under SCLASS, class 42 with effect from 16/8/2019, and defendant number 1 stated that the word SalesCan is proposed to be used by it in class 42, which pertains to technological services, and obtained registration of the mark by suppressing the existence of plaintiff's trademark, which is phonetically and visually similar to the word SalesCan, and also by suppressing the fact that plaintiff was already in the business of providing technological services to its clients under the name within quotes, capital SASCAN, for more than 20 years. First, Forum TM under trademark under T capital M capital dash A capital A, dated 16/8/2019, filed by the first defendant before the Registrar of Trademarks, Chennai, seeking registration of the word SalesCan, is produced as a document by the plaintiff along with the plaintiff. First, plaintiff came to know that a company has been incorporated on 28/2/2019 under the name SalesCan Technologies Private Limited, which is the second defendant, and defendant number 1 and 2 were associated with Sri Raman Vaidyanathan and Miss Suguna Sudharma so and so. Page number, page number 17, in page number 17, para 15.1, as promoter so and so. First, plaintiff found out that there is a website with an address www.salescan, small letters, .ai, offering technological services using artificial intelligence and data analytics for the purpose of improving the performance of its clients and sales. First, it is also contended that goods and services are classified in India for the purpose of trademark registration as per the International Classification of Goods and Services, hereinafter referred to as NICE classification, published by the World Intellectual Property Organization, for short, within brackets for short, WIPO, WIPO. First, the WIPO, by virtue of Rule 20 of the Trademark Rules 2017. First, as per the set classification, class 42 would read as under. Para 16. Next para. Plaintiff, being the multinational company offering with its offices across the world, was offering services in several disciplines under the broad spectrum of technological services as aforesaid, which includes the research and development products, performing data analytics and betterment of the business of its clients using artificial intelligence and machine learning for creating solutions for its clients, and therefore, the registration of the word SalesCan and obtaining the trademark has thus resulted in interfered with the established business of the plaintiff and sought for declaring of the suit as referred to supra. Post, next para. Upon service of the suit summons, defendant entered appearance and filed written statement denying the plaintiff governments in toto and maintain that it is catering to the needs of its clients in a separate and exclusive structure, exclusive area, and therefore, the plaintiff's suit is not maintainable. First, defendants also contended that the registration of the word sales can by the competent authorities is based on the requirements of law to be followed, and therefore it is the malafide conduct of the plaintiff in filing the suit, and the same needs to be dismissed with exemplary cause. First, defendant maintained that mark sales can within quotes is a registered trademark, and defendant has a statutory right to use the said mark, especially under the right bestowed by section 28 within bracket subclass 3 read with section 30 read with section 31 of the Trademarks Act, and plaintiff having initiated the proceedings before the Intellectual Property Appellate Board in relation to the defendant's trademarks, namely sales can. Further proceedings in the suit needs to be stayed. First, defendant also maintained that areas of operations of the business of the plaintiff and defendant are totally dissimilar, and therefore, the trademarks of the plaintiff and defendants would not have any contradictory results. Is not having any bearing with each other, any bearing or connection with each other, and therefore, suit of the plaintiff is vexatious and based on imaginary cause of action and sought for dismissal of the suit. First, defendant also maintained, next para, defendant also maintained that the trademarks of the plaintiff and defendant would not be, there is no similarity between the trademark and the defendant either in the visual or in phonetics or in the structure, and therefore suit of the plaintiff is to be dismissed. First, defendant further contended that the only word that could tally with that would interfere with both the trademarks is the word within bracket within quotes small within brackets within quotes KEN, and said the word KEN appears in several trademarks, and therefore plaintiff cannot maintain a suit against the defendant and sought for dismissal of the suit. First, plaintiff inter alia filed 3 applications seeking an order of injunction, wide IA number 1 to 3. First, next para, wide IA number 1 to 3. First, the applications are opposed by the defendant by filing written objections. First, the learned trial judge heard the parties in detail on the applications filed by the plaintiff and opposed by the defendant in a detailed manner, heard in detail, and by order dated 20th January 2021 dismissed all the 3 applications filed under Order 39 Rule 1 and 2, Schedule Section 151 CPC. In IA1, the prayer is as in the prayers in IA 1 to 3 are as under. First, next para. The applications are supported by the affidavit of the authorized signatory of the plaintiff. First, authorized affidavits of Assistant Vice President Legal, who is the authorized signatory of the plaintiff, wherein, comma, reiterating the contents of the plaint, comma, reiterating the contents of the plaint, comma, plaintiff maintained that they are entitled for order of injunction against the defendant. First, in the objection statement of the defendant, comma, the contents of the written statement were reiterated and contended that defendant has employed 100 employees who are entirely dependent on the salaries paid to them, and defendant's business and turnover is entirely dependent on the use and reputation and goodwill of the name Sales Can Portnally, and the niche sphere, NICHE, niche sphere of the business it is associated with, and they have got the high ratings in www.g in the small g number2.com, and therefore sought for dismissal of the injunction application. First, on behalf of the parties, comma, following judgments were relied on by the parties before the trial court. First, on considering the trial contention of the parties, comma, the trial court formulated following points for consideration. First, next para. Based on the material placed by the parties, comma, the learned trial judge considered the arguments put forth on behalf of the parties, comma, in the light of the principles of law enunciated in the decision relied on by the parties, comma, the learned judge concluded that plaintiff has not made out a prima facie case for grant of injunction as prayed, and dismissed all the three applications. First, next para. Being agreed by the same, comma, the plaintiff has filed the present appeal. First, next para. Reiterating the grounds urged in the appeal memorandum, comma, Sri Manish so and so vehemently contended that the trial judge has misconstrued the scope and object of Order 39 Rule 1 and 2 in dismissing the application having regard to the facts and circumstances found in the case on hand, whereby, comma, the plaintiff is put to great hardship and injury and sought for allowing the appeal. First, next para. He further contended that the word Sasken and Salesken are practically similar, both in phonetic as well as in the design, and whereby, comma, the right of the plaintiff per se has been infringed by the defendants, and therefore, comma, the action sought for by the plaintiff was well within the scope and ambit of the rights of the plaintiff insofar as seeking an order of injunction against the defendant, and having not been able to properly appreciate the rival contention of the parties and dismissing these applications filed by the plaintiff in the impugned order, comma, impugned order has resulted in miscarriage of justice and sought for allowing the appeal. First, per contra, Sri Dhyan Chinnappa, current senior counsel, representing the defendant, comma, supported the impugned judgment by contending that the area of operation of the plaintiff and defendants are altogether different. The clientele of plaintiff and defendant are altogether different, and the marks are also totally dissimilar, and therefore, comma, the contention of the plaintiff that their business has been affected by the usage of the registered trademark of Sales Can by the defendant at no stretch of imagination can be countenanced in law and sought for dismissal of the appeal. First, next para. In support of their cases, their arguments, comma, the appellant and respondent have relied on following judgments. First, this court perused the matter on record meticulously in view of the rival contention of the parties. First, On such perusal of the material on record, following points would arise for consideration. Whether the plaintiff has made out a prima facie case that the trademark of the plaintiff and defendant are similar, and therefore, right of the plaintiff has infringed the rights of the, therefore, the right of the plaintiff has been infringed by the usage of the word sales can by defendant and whereby is entitled for an order of injunction. First, whether the refusal to grant the injunction in favor of the plaintiff has resulted in hardship and irreparable injury to the plaintiff. What order? District Municipal.